Good morning, good morning, good morning. Happy Thursday. Gosh, I almost said Tuesday because I've been traveling. It's December 7th. We are covering a lot of court filings today. So, just one topic today because there's so much. Replay crew, love you. All the timestamps will be down below for the different documents, but just one topic today with a road so far. The Gabby Petito Brian Laundrie civil suit is between Gabby Petito's parents and Brian Laundrie's parents. It's a very unique way to use the civil law in the way that it is being used. We're going to talk about that. And today is a day that we are going to have to really put into practice, like moral obligation and legal obligation, and the fact that morality and legality don't always go hand in hand. So the thing you would hope somebody would do might not be something they are legally required to do, and where the law does or does not require people to act and or not act in circumstances. We're also going to learn a lot of new information about this case. I'm sure you've seen the headlines. We're going to go beyond the headlines into the legal filings and talk about whether the legal filings matter, like whether the new legal filings matter to this fairly unique civil lawsuit, or whether it's just closure and good to know that what's been said in depositions about the Laundries. So what we've learned is that Brian Laundrie's parents knew. Now, all of the covering the case that I've done, I have very strongly held out for the if they knew this, then this, because we did not have court evidence of that. We had a lot of like, oh, maybe, but we did not have court evidence. We now have court evidence of what and when Brian Laundrie's parents knew. There are hearings coming up later this month over what attorney Stephen Bertilino will say or not say. We have a lot to discuss about attorney-client privilege, and there's so much going on. So I see the comment in the chat, and I'm sure there's a lot of that. Shauna Michelle said, we knew they knew. So there's a difference between like knowing and having evidence of the thing. So the evidence of the thing now supports the knowing, because everybody was like, we knew this, but now we have evidence to back up what was known. So, Alice, can we do a road so far? I'm absolutely going to do a road so far as we get into this. So good to see everybody this morning. When we get to Q&A at the end, I will tell you a little bit about my trip to LA, my time at the Google headquarters in LA, some of the other creators I got to hang out with, and then just time back in LA and how that is after moving. So we're going to do all of that. If we have time after we get through the legal documents, because there's a number of them, we will get into maybe a quick interview with Brian Entin, and then do a lot of Q&A. So just the one topic today, because there's so many filings, and we're going to talk about it. So I see, Shirley, I've seen this question in the chat over and over and over again. We're going to talk about that after we get into the court documents. So we've got to go through what's been filed in court first. So with all of that, you guys, that's what we're going to do. We're going to, today, please keep in mind, today is an exercise in morality versus legality. And there are a lot of things in the law that are not unlawful or are not actionable that do not seem right. So that's the line that we are having a conversation about today. This is where people get mad at lawyers like a lot, because there's times, especially when you're in like full lawyer mode, like lawyer mode is like a separate setting to human mode. When you're in like full lawyer mode, there's times that lawyer mode can come across cold or insensitive because it's calculating cases. It's calculating not so much in the gray zone. It's calculating, the legality of a situation or not, the ins and outs of a situation or not. And it's not taking necessarily at that point into time the morality of a situation. It's just coldly talking about the legality, which is a very necessary part of lawyer mode. You have to be able to shut down the emotional side to get to the legal side, because sometimes the emotional side can cloud it. When we have those conversations, I try to parse both. And I try to parse both so we can all process together the emotional, moral, like right and wrong side, and then the legal side, because you've got to know what your feelings are about a thing before you can set the feelings aside. Lawyers get very well trained to set the feeling aside, and then they're like, oh my God, lawyers are such dicks. It's like, oh, they forgot to turn it back on. They forgot to set themselves back to human mode. They're default, they're stuck. Some of them just get stuck in lawyer mode. It's like, ouch, stuck. You've gotten stuck in lawyer mode, and the emotional side of it's turned down. And when somebody doesn't acknowledge feelings in a conversation or acknowledge the emotion of a thing, it can feel very cold and sometimes very mean and sometimes very dickish. Some lawyers are also just dicks, I mean, aside from it, but sometimes it's the way that a conversation goes. They get stuck in the lawyer mode setting and they don't default back to the human mode setting. It happens to me too. Absolutely happens to me too. So it's hard to sometimes navigate the two as an attorney, because you're so used to turning off the human side. Brian told a story on our members only live stream that we did last month with my husband about how we were at lunch with a bunch of DAs, and he came to lunch with us because he had come to the courthouse to do jury duty that day and didn't get selected for jury duty. But he came to my courthouse to do jury duty, and then we got to go have lunch with a bunch of my DA friends, some who we know, some who we didn't. And he was talking about other tables getting up and moving away from the conversation where we were. And it's like, oh, we're in lawyer mode. Apologies that we're in work mode. Wolfhard said, it sounds like a massive disassociation technique. I mean, you're not wrong. But I think that a lot of careers have this. So before I became an attorney, I had lifeguarded, but I had also worked as an EMT. And when I worked as an EMT, a lot of the work that I did was inside emergency rooms in an emergency setting, not in an ambulance setting. I hated working as an EMT. God love all of you that can work in medicine. I absolutely could not do it. I am very, very sensory sensitive. This is not the job for me as a sensory sensitive person. I also could not work in ambulance because I get very motion sick. Emily, what was this plan? I don't know. It was a bad plan. It was not for me. But you get into work mode, and you see this in hospital and medical settings too, where your emotional side needs to not come first because you have a job to do and you need that side of your brain to work. So are some people better at it than others? Yes. Can it cause trauma? Absolutely yes. Is it difficult to learn to navigate? Absolutely yes. Can it be navigated? Also yes. But you learn to segment the critical thinking and the emotions, and that is sometimes necessary as part of your job. But I also find, to be fair, as a parent, sometimes it's necessary. Like, there's things my kids do that absolutely either trigger me or trigger things that happened to me when I was younger. And to parent it well, sometimes I need to put the emotion aside, process my own emotions later, and go into the parenting mode and handle what needs to be handled first, and then deal with my emotions. Because when my kid slips and falls and breaks a shoulder, it doesn't help if I panic. It just makes it worse. So we do this in a lot of different contexts, and we're going to do this today a little bit. We're going to do both. We're going to acknowledge the feelings, because I know we have a lot of feelings about this case, and we're also going to go through the law side. So, Carrie B said, still haven't managed to learn that, Emily. Look, it is a constant, lifelong practice. It is a process of learning. I don't think it's ever done. Just a process of learning. Casey Cat said Steve Bertilino does have a human side. He's just we'll get there. We'll get there, because sometimes lawyers doing lawyer things come across as, well, dickish. You have to separate the two. This is something I loved in law school. I was much less compassionate in law school. I'm like, law says this. What's everybody crying about? Law says this. Law says this. I have become more compassionate. was very much my black and white thinking was very much on display in law school. Like, law says this. What? Well, in class would be like, girl. And I'm like, we're in class. It's like a theoretical setting. We got to put this on a test. All right. With all of it, we're going to get rolling. We've got things to do today. I want to know where you're coming in from, what you're drinking. So I'm back in Middle Tennessee after being in California for a few days. I got off the plane last night. I was like, whew, the air's got a chill in it. It feels like fall. I'm back home. So I have hot coffee this morning from my coffee maker. So cheers. Let's roll the intro. We're going to do a road so far in a minute, but you guys, you know how it is. I just traveled. So I had to run around the house and find where my actual earrings were for streaming. But then my earrings and my lippy were not in the same place. And then my reading glasses, which is what I use for streaming, because I need to be able to see my computer and my eyes now need several different prescriptions depending on what I'm doing because old. So then I had to go find those too. Emily, why isn't anybody ready this morning? Because I'm not all the way unpacked yet. That's why. Emily, why didn't you unpack last night? I was catching up on Real Housewives of Salt Lake City. It needed to happen.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
You guys are having the best things. Patrick, hello in Moscow, Idaho. I'm sure you're glad we're not talking about Moscow today, but cinnamon spice black tea sounds amazing. Hello, Sherry in Las Vegas. What's up? Water gang, like I'm hydrate and caffeinate this morning. We got to do both. But you guys have some delicious things going on today. So I love it. Hello, my fellow Tennesseans. It's so hard getting things back in place after traveling. I'm so bad at it. I'm getting much better. Like I have a better system now, but when you have executive functioning issues, packing and traveling are one of those things that like taps into all of my executive functioning quirks. And so it can be a bit of a challenge, but I flew into the proper state. I flew into the proper airport. I made my vehicle rental to the proper airport on the proper day of the proper year. I've done that too. I had my hotel reservation for the proper day in the proper city. So, things went pretty smoothly, except that I had a very long jaunt yesterday when they changed gates like halfway across LAX, but it ended up being kind of a lovely jaunt. So it was fine. It's fine. Everything's fine. I didn't have any disastrous travel, and it was the end of the year. I got to fly in the unexpectedly bougie seats. I end up sometimes unexpectedly booking last minute travel, but this last minute travel, the direct flights from Nashville were booked. So I ended up routing through Atlanta, which I don't normally do, but routing through Atlanta, they were repositioning some of the international flights. So I got to do the fancy seats, and I was real excited about it. I was like, I don't fly international. Well, my passport has been expired. I don't fly international that often. My passport, not since like 2019. And then somewhere during a pandemic, my passport expired, and I was like, fuck. So I haven't gotten to fly in the fancy seats. And I was like, fancy seats. It was fun. End of the year, I was like, yay. That was it. Fancy seats. Normally it's just a quick hop on the domestic flights. So it was a nice travel experience. My mother was like, so bougie. I was like, I was like, Mom, obviously. Hello. Have you met me? I'm old. I need to be comfortable. I am a Taurus. I want to be comfortable. I don't care how expensive a thing is if it's comfortable. Most of my clothing is from Target. It's soft and comfortable. I'm fine with soft and comfortable. It's more comfort than it is bougie, but sometimes those things go hand in hand. All right. We need to do a road so far. So let me pull this up. Before we get into our road so far. So Larissa said, I found my love of law through you, and now I'm in school to be a court reporter. Amazing. You're going to know all the tea. Oh my God, Larissa, if you work in courthouse settings, you will know all of the tea. It's like a freaking TV show. It's kind of like Grey's Anatomy, but in a courthouse. All the tea. And if you work in depositions, you'll get to see all of the nonsense. It's going to be lots and lots of fun. All right. So I'm going to tell more travel stories when we get to Q&A. If you have not downloaded the Law Nerd app, it is holiday time, and we've got some court hearings coming up that I'm going to be covering. Sometimes those things happen day and date, and I'm like, Mods, can we do this? The way I let you know that I'm doing that is on the Law Nerd app. So if you do not yet have the Law Nerd app, now is the time. Free app, iOS, Android. It just keeps you in the loop with what I am doing and when I am streaming. You have control over your notifications. And it has been so helpful to let you know when QuickBits is dropping, when I have new shorts up on the QuickBits channel, when there's a new live stream, when there's a new podcast episode like yesterday, what we're doing. It's the easiest way for me to communicate with you all. For those of you that are telling me how much you love the app in the chat, thank you. I see you. I am so proud of my incredible team. When I said I would love to get this done, they were like, we will make this happen. And so this was a huge team effort, and getting the app to you guys is amazing. We have so much to come for the app in the new year. So yes. All right. So with all of that, the app will keep you in the loop. What else do we need to do? I need to say thank you. B2 gifted an incredible amount of memberships. Thank you, B2, for always being incredibly generous with the Law Nerds. That is a ton of memberships today. So for all of you that have become new members through Bridget and B2's gifts today, welcome. You can go to your members tab in the community tab space on YouTube and find all the members only live streams that you might not have seen yet. Matt Bond, I see you in the chat. Good to see you. And then all of you are chatting about something that happened last night, and we're going to talk about that real quick. Hello, Spiffy, Legal, Mumbo, Jumbo, Talkie, Sister from Another Mister. How many of you were on Law and Lumber's members only last night? Because I heard that he shared some news on his members only. So here's what I would like to do, because I already saw you guys talking about it in the chat. So it's not me spilling the tea. He talked about it yesterday. I am just saying, look, we don't brigade other creators. We don't raid other creators. But Rob over at Law and Lumber did just get engaged. So if y'all would like to pop by his channel or the Twitter sphere and congratulate him on his pending nuptials, that would be sweet. So, Rob is engaged. I'm incredibly excited for him. So I think Ian Runkle is selling commemorative t-shirts that say pour one out for the thirst. Their friendship makes me giggle. So I think there are commemorative shirts. Rob, we spoke of you, Rob. So be sure to go congratulate Rob on his engagement. And for all of you that saw it in the members chat, I'm sure you already have, but it's such a nice thing to see so many well wishes. And I know that means the world to him. And I know that, when Hogue went through his stroke, seeing the outpouring of love made me so happy, because I can only outpour so much love, but seeing the whole community do it, it feels like getting to amplify the positivity, and it's so good. So go send Rob all of the congratulations and love, because I am so incredibly happy for my friend, and he's incredibly happy. And isn't that what matters? Isn't that what matters? Before we talk about things that have gone horribly awry, we're going to celebrate the good and the positive. And then we're going to talk about things that have gone horribly awry. Yep. Good and positive first. So huge congratulations, Rob. Ian's got commemorative shirts. I'll share those in the community tab later today. I forgot to do that earlier. So, all right. For those of you asking about stacks at Rob's bachelor party, I don't get the sense that that's how Rob rolls, but we will continue to make fun of him about it. So that is where we are at. So congratulations to Rob and Rob's mischief manager. It's very exciting stuff. All right, y'all, we need to get into this case or we're going to stream for 100 years. And I don't know if I have the capacity to stream for 100 years today because I am tired. I am tired. Sandra P in the chat says, does this mean we cannot talk about Wood Daddy Stacks anymore? No, it does not. No, it absolutely does not. It absolutely does not. All right. Let's do a road so far. Let's get into all of the things, shall we? Shall we? Emily Rose said, tell us about your coffee cup. I will have to find it. It's a double-barreled cappuccino mug. Specifically. Because, okay, cappuccinos, if I say it differently than you say it, I apologize. The cappuccinos. Because of the foam on the top, prefer like a round bottom. Like we need a fat bottomed mug. We need a roundy bottom. We need like a juicy bottomed mug so that it can properly swirl. So a standard mug that has like the kind of flat bottom is not it. We need like a round bottomed mug for a good like cappuccino situation. So, or a flat white. So that is what we have going on. And it's double barreled, so it keeps it a little bit warmer, which is key to me in the winter. All righty. Let us go. Yes, exactly. For those of you in the chat saying round bottom mugs, you make the rockin' world go round. That's exactly what it is. We need a round bottomed mugs. All of you, thank you for picking up immediately what I was putting down. I appreciate all of you. So let us go. Let us go. Where was I? Oh, we need a transition. We need to transition and do a road so far. All right. I don't know what the good transition for this case is. There's no good transition for this case. Maybe just a little maybe a little stretch. Oh, we got to transition. All right. We're transitioning. We're going to swoop. Somebody said roll the intro again. No, I'm not going to roll the intro again. Mostly because it'll kill rewatch time on the replay. We're streamers. We still want people to watch. Okay. All right. We're gonna take a pivot. We're gonna take a real quick pivot. Because this case is wild, but it's not a case you can really joke about because it's just too freaking tragic. Let's swoop a doop and let's get into this case. Emily, you've procrastinated. I haven't. We've talked about all the things. Let's go. Let's do a quick road so far. My quick road so far is going to be about the civil case that's going on, not the underlying case. The underlying case is this. As many of you know, Gabby Petito and Brian Laundrie were on a kind of van life across the United States. When she went missing, he went back to Florida in her van. It was like 10 days later before she was reported missing by her family. We're going to get into the circumstances surrounding that today. He then went missing. There was worldwide media attention looking for her. She was found deceased. He was found later on deceased by self-inflicted wound. He left a note confessing to the fact that he had killed Gabby Petito. That was known after her autopsy was done, that she had been murdered. While there was speculation that he was the one that had done it, of course, there was no court process yet. Once he was found and his note was found, it was uncontroverted that he killed Gabby Petito in Wyoming. After that, the criminal case that had been initiated regarding him using her access cards or debit cards, that had been dropped because he's deceased. There's no prosecuting him. There was a civil lawsuit between her estate, her family, her estate, and his estate. That was a settled judgment for like $25,000. That was all that was left in his estate. We're going to get into that number in a little bit. And after that, a civil lawsuit was brought between Gabby Petito's parents, the Petito Schmidt family, and Brian Laundrie's parents. So Gabby Petito's parents are suing Brian Laundrie's parents for intentional infliction of emotional distress and more. We're going to get into their third amended complaint today, and we'll go through all of the allegations in the complaint. Maybe we'll just do that first because that'll help. So it is a very unusual use of intentional infliction of emotional distress. From the beginning of covering this case, one of my opinions or perceptions of the case has been that part of the goal here was for the Petito parents to get this case to discovery to find out what was known. They seemed to me that they wanted answers more than necessarily a monetary recovery. A monetary recovery isn't going to bring anyone back. Sophie, we're going to get to this question as we go through these court documents, and I'm going to ask you all that in a few minutes because we've got a lot more information about this case in these court filings. So this is a very unusual and new use of intentional infliction or negligent infliction of emotional distress. And we are going to go through all of that. Crystal in the chat said, FYI, I think YouTube is unsubscribing peeps. It's been happening over the last couple of weeks. We've had a number of members who were like, I'm still a member on the channel, but I got unsubscribed. It's that time of year, which is strange. So I think what the Petito family was seeking in this lawsuit was answers, was information, and was getting to the bottom of what was known by who and when. And this case wasn't clear to me that it was going to survive a motion to dismiss. It's a very unusual way to use this law. It survived the motion to dismiss and went to discovery. Depositions are going on, and they are still fighting over discovery. And with the fight over discovery, a lot more information has come out. That's the information we're going over today. This is going to go to hearings later this month. We're going to cover that hearing live. I imagine that there's going to be court coverage or video coverage of that hearing later this month. It is the same judge that did the Maya case that is doing this case down in Florida. So we're going to see that hearing. The hearing is mostly going to be surrounding a motion to compel. We're going to get into the motion to compel today. So today we are going to talk about the third amended complaint, the motion to compel, the request for production, and maybe we'll look at the witness lists. But we're going to start, I think we're going to start with the third amended complaint that was filed November 30th. And then we'll kind of work backwards a little bit from there. So later on this month, we're going to cover the Bertilino hearing regarding a motion to compel testimony. We're going to talk about that later. So, third amended complaint with new information and motions to compel. We've got to talk a lot about attorney-client privilege. A lot of questions are going to be asked about criminal liability. I'm going to get to those at the Q&A. So I know everybody wants to know about criminal liability. We'll get there. Michelle West said, I heard Judge Carroll was no longer the attorney or no longer the judge. I have not seen that. So I have not seen that. So if that changed, I have not seen that. And I'm going to pull up the latest I'll pull up remind me when we get to Q&A, I'll go back and pull up the docket and see if that's changed. I haven't seen any transfer orders in this because it got transferred to Judge Carroll from a different judge that had it previously. So we're going to start with the third amended complaint. There had been motions over filing a third amended complaint. That motion was ultimately granted by the court. So now that there is a third amended complaint, we're going to go through all of it. I've gone through the other complaints. So if some of it seems repetitive, that's why, but I think it's important to get into those. So you ready? Y'all ready? Let's get to the Petito Laundrie, third amended complaint. Emily, hey, I pushed the wrong button. I was trying to share my screen and I pushed stop camera. That's Emma, that's the wrong button. It's not the right. I have pushed the wrong button. Look, man, I miss one stream and it's like I've never done this before. Streaming is an adventure. Me, as I'm telling other YouTubers, streaming is great. You guys need to stream more. Stream everything. Streaming is so much fun. And then they're like, girl, what are you doing? I don't know sometimes. All right. There we go. Let's make sure you can see this. That shouldn't block any of the actual text because this is formatted properly and you can still see my face. My face. So MLS Making Laws Simple said there's no reason why this case survives summary judgment. They haven't done summary judgment case. For anyone who likes the case, just know you are asking, where did it go? Asking, wait, why can't I read this? Oh, there it is. Just know you're asking for society where it's okay to sue someone to force you to speak. We haven't even gotten there yet, Making Law Simple, but this case has not survived summary judgment yet. This has not come up on summary judgment. And we're going to talk about that later because there are ins and outs of the legality morality, CEG my rant at the beginning of this stream. So we're not there yet. Third amended complaint. And I also think it's fair to want to see how this case plays out, but also not necessarily knowing. So no, MLS, no, there has not, we are not at summary judgment yet. They are still in depositions. So this case has not gone through summary judgment. I think the summary judgment hearings will be issued. It did survive the motions to dismiss. And even that was quite a substantial fight. So third amended complaint comes now. Joseph Petito and Nicole Schmidt, which is why I call them the Petito parents, by and through their undersigned counsel to file the third amended complaint. Again, the court granted them leave to file this complaint. I'm not going through that motion. It's not super relevant for our purposes. Venue, jurisdiction, amount, residencies. The Petito Schmidt family are the parents of Gabby Petito. The Laundries are the parents of Brian Laundrie. Defendant Stephen Bertilino, resident of New York State, is a lawyer licensed to practice law in New York. Again, the lawyer is also being sued for things that the lawyer said, perhaps on the basis of speaking for their client. So keep that asterisk in mind, because generally lawyers cannot be sued for the things that they say for their client in the context of litigation. So litigation privilege is going to come up here, but litigation wasn't specifically pending. So this is a very interesting kind of aside, but I think there is a strong argument that Bertilino was not representing the Laundries at this time, and perhaps Bertilino was representing Brian and not the Laundrie family. So that is a question that we are going to keep in mind as we go through this to see what's alleged. So suing the lawyer over something they said on behalf of the client is an interesting quirk. All of you asking, what about Depp Heard? Depp was sued for what his lawyer said. The lawyer was not sued. Depp was sued. So let's continue on. Defendant Stephen Bertilino, lawyer, New York. At all times relevant to the case, the within cause of action, Stephen Bertilino was acting as the agent for Christopher Laundrie and Roberto Laundrie. They're alleging that. I don't know if he was hired by them or if he was not hired by them. He might have been representing Brian Laundrie, and if he was, it's going to be hard to argue they're an agent. These factual determinations come up during summary judgment motions. So we've just recently covered a summary judgment motion in the Idaho defamation suit. Factual determinations can come up during summary judgment. During a motion to dismiss, you just have to plead it. Brian Laundrie and Gabby Petito became engaged to marry on or about July 2nd, 2020. On July 2nd, 2021, they left New York in a van owned by Gabby Petito to take a trip to the Western United States, which was expected to last for several months. Prior to the trip taken by Gabby Petito and Brian Laundrie, Joseph Petito, Nicole Schmidt, Christopher Laundrie, Roberta Laundrie had a cordial relationship. They were engaged. The families had a cordial relationship. Petito had hopes of becoming a travel influencer, a quote unquote van lifer, and document her cross country travels on social media sites such as YouTube, Instagram, and TikTok. During the course of the trip, Petito called her family almost daily, including her parents and her siblings. The last communication that Petito had with her father, Joseph Petito, was on August 21st, 2021. The last communication that Nicole Schmidt, her mother, had with Petito was on August 27th, 2021. It is believed that on August 27th, Brian Laundrie murdered Gabby Petito. The cause of her death was blunt force injuries to the head and neck with manual strangulation. Gabby Petito was 22 years of age at the time of her death. After Brian Laundrie murdered Gabby Petito, Brian sent text messages back and forth between his cell phone and her cell phone in an effort to hide the fact that she was deceased. On August 27th, it is believed that Brian Laundrie sent a text to Nicole Schmidt, Gabby Petito's mother, in which he referenced Gabby's grandfather, Stan, by name. Gabby never called her grandfather by his name. On August 29th, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, in a frantic telephone call that Gabby was quote unquote gone and that he needed a lawyer. On August 29th, Christopher Laundrie and Roberta Laundrie spoke with Stephen Bertilino, advising him that Gabby Petito was quote unquote gone, that Brian needed a lawyer, and sent him a retainer on September 2nd, 2021. I'm interested to know more about whether they sent Bertilino a retainer for Brian, for them, if there was a conflict waiver, who was the client, who was not the client, or is it just a foregone conclusion that the Laundries were the client and Brian Laundrie was also a client? There are questions here for me. And so as I'm going through this, I'm going to also point those questions out to you. We're going to just do good old fashioned issue spotting. This is how I process documents. I read the thing and I'm like, what about this? What about this? What about that? This information is coming from the depositions. So they are alleging things that they have now learned in deposition and putting it into the complaint. On September 2nd, and as we get more into this, the type of lawyer hired is going to matter. On September 2nd, 2021, on behalf of Brian Laundrie, Stephen Bertilino entered into a fee agreement with Fleener Peterson. Fleener is an interesting name. Fleener Peterson, a criminal defense law firm located in Laramie, Wyoming, for the purpose of representing Brian Laundrie. So Bertilino chose to hire a criminal attorney. And this is where, when they argue what the interpretation of gone was between the Laundries and Bertilino, if someone was breaking up and dealing with property, a criminal defense attorney is not the person you are going to call. You are going to look for a family lawyer. Like if my friend called and said to me, my husband is gone, I have to deal with the house, I think I might need to file for divorce, blah, 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 blah. I'm not going to tell them to file or call and retain a criminal defense attorney. That's not what we're doing. What I'm saying is we need some family law involved here. We got to deal with, equitable division of the assets. If somebody calls me and says, hey, this is for me, so-and-so is gone, I need a criminal attorney, I'm going to be like, tell me less. And if you need a criminal defense attorney, it gives a more full picture of the fact that they're interpreting gone as not just somebody left, right? So Stephen Bertilino helps retain a criminal defense law firm. Prior to the time that the firm was retained, and again, you're allowed to retain lawyers, but the way this is going to be interpreted by a jury is I think the way that I'm interpreting it. But we'll see. Prior to the time that the Fleener Peterson firm was retained, Stephen Bertilino contacted other attorneys in Wyoming to represent Brian Laundrie, including a public defender's office in the same county where Gabby Petito's body was ultimately discovered. How do you know what county her body's in, though? I mean, I'm sure there's more than one county in Wyoming. And the national parks are covered by multiple jurisdictions. So how do you know what county? How do you know what county? Just saying. So when we're getting to the, hey, what exactly was told, enough was told that they were contacting the public defender's office in the exact same county where her body was ultimately found. On August 30th, Brian Laundrie sent a text message from Gabby Petito's cell phone to her mother, stating that there was no service in Yosemite Park in an effort to deceive, and again, this is speculative for the complaint, in an effort to deceive Gabby's mother into believing that Gabby was still alive. That's going to be argued. This is argument. I don't think it is an unfair interpretation, but it is going to be argued. On September 1st, Brian Laundrie returned home to his parents, Christopher and Roberta Laundrie, driving Gabby Petito's van. So September 1st, I think she was reported missing by her parents on September 10th or 11th. We'll get there. He called them frantically on August 29th. Got them to hire a criminal defense attorney, including calling the public defender's office in the county where her body was recovered. And then returns home on September 1st with her van and without her. A lot of people had speculated about this, but now we have quite a lot more information. So, Cheryl Ray said, if she was missing, he didn't notify the police, he left. Yeah, he didn't leave right away. He got himself a criminal defense attorney, and then he left. Didn't call the Rangers, called his parents to get a retainer on a defense attorney. Does this make his parents liable for anything? We're not there yet. We're just going through the facts. Well, the allegations. Some of this is fact because it's coming from depositions. I think this is a typo. Okay, we're going to keep going. So from September 1st, Brian Laundrie returned to the home of his parents, Christopher Laundrie and Roberta Laundrie, driving Gabby Petito's van. At this point, or after this point in time, there was no contact between the Petitos and the Laundries. So after September 1st, the families had no contact. From September 10th, check with client. I don't think that's supposed to be in the final version. Things happen. This is why you highlight it. Highlight it. Highlight it so the check with client parentheses does not get filed. Just saying. But I will always point out the errors because I think everyone needs to remember that we're all human. Lawyers are human and we all mess up stuff at work. And at the end of the day, it's going to be fine. Right? It's why I pointed out we're all human. Somebody should have proofread, but we are all human. From September 10th, checks with client, until September 19th, when Gabby Petito's remains were found at the Spread Creek dispersed camping area in Wyoming. Remember, she was not reported missing until in that time period, but it was closer to September 10th that she was reported missing. And then other van lifers actually helped find her in this case. So her remains were found at the Spread Creek dispersed camping area in Wyoming. Plaintiffs were extremely distraught and were attempting to locate Gabby. Yes. So during that window of time, they were extremely distraught and attempting to locate Gabby. Absolutely believe that that is true. Absolutely believe they'll be able to prove that. Absolutely believe that a jury will believe them. Whether his parents contributed to that, we will see. While Gabby Petito's family was suffering, the Laundrie family went on vacation to Fort DeSoto Park on September 6th and 7th. They went on vacation knowing that Brian Laundrie had murdered Gabby Petito It is believed that they knew where her body was located and further knew that Gabby Petito's parents were attempting to locate her. So, what lends weight to this allegation for me is the fact that the defense attorney was contacting the public defender in the same county where her body was located. If he contacted every public defender in the state of Wyoming, that's different, but also the park covers more than just Wyoming. So they knew enough to know that they needed an attorney in Wyoming and to know that they needed to contact the public defender in that jurisdiction in Wyoming. So it is my educated guess that they knew in general where she was located, where her body was. I will remind all of you that the law does not require you to snitch. Look, this is where the morality and legality is hard before we get into any more of this. The Petitos have lost their child at the hands of her fiance. It is an incredibly horrible violation. It is hard to wrap your head around. This is different. This type of murder is different than somebody being killed in a car crash. It is still tragic. It is still sudden, but the violation is different. It's a different thing. So they don't know where their daughter is. The people they believe that knows where their daughter is are on vacation for like 4th of July with their son, who has killed his fiance at this point and driven her van back to their home. The law does not require them to say anything. If Brian Laundrie called his parents and said, "Get me a lawyer, Gabby is gone, I need a criminal defense attorney," they're not required to do anything with that information. What they cannot do is lie to the police about it. And it doesn't seem that they did. They chose not to talk. The law cannot make you talk. It cannot force you to say, "Our son called and did that." So for all of you saying, "Wouldn't it be aiding and abetting?" We're going to do more of this at Q&A, but I don't think we can even get to Q&A. That girl and many of the rest of you in the chat have said, "Wouldn't that be aiding and abetting if they knew?" No. Not if, at this point in time, up until her body is found, the police are not looking for him. There is not a warrant out for him. There is no evidence that they are cleaning the van, hiding the van. They went on vacation with him. He's not on the run. He's not being investigated by the police. They don't know that Gabby Petito is dead at this point. So they're not aiding and abetting anything. If there is evidence that they cleaned out the van for him, that might be aiding and abetting. We don't have evidence of that. So if they were, this case doesn't have a murder weapon, but if they had taken a weapon, a knife, a gun, or whatever had been used in a crime, and they had taken it and hidden it, that could be aiding and abetting after the crime. But there's no evidence they did anything other than not tell anyone at this point. Not telling someone in this circumstance is not a crime. They are not required legally to say anything. The morality of this whole situation is well and vastly different, but what we're talking about is the legality. They are not required to say shit. They're required to not lie. You must not tell lies. They cannot lie to law enforcement. If you lie to law enforcement, then you might be in the realm of aiding and abetting, obstruction of justice, impeding, etc. But they didn't lie. They said nothing. I Love Pie said, what about harboring a fugitive? At this point, he's not a fugitive. At this point, no one's looking for him. You would think if he stayed alive, he would have picked crime of passion. I don't know about that. What about harboring a fugitive? We did that. Wouldn't that mean they're obstructing justice? No. What have they done to obstruct justice? No one's asking about where he is. They're not hiding him. They're not lying to law enforcement. They're not required by law to report anything. So they are not required at this point to do anything. Right? Even the letter that she wrote to her son, which seems to indicate that she was willing to help him do anything, unless there's action taken, the letter saying, I'll help you do XYZ, and we can go back through the letter if we want to. Even the letter saying, I will help you do whatever, I still love you, blah, 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 blah. That the burn after reading, the walk the dog was stuck in my head, but the burn after reading letter, which seems to have been written after they knew that Gabby Petito was dead. The burn after reading letter, she's offering, I think, to help him after the fact, but there's not evidence that she did help him after the fact. And even if she did help him after the fact, there has to be some evidence that they did something more than like he took the car and drove off and took his own life. That's not going to fall into where they're going to prosecute them for aiding and abetting after the fact, right? Wouldn't this fall under hindering prosecution? Nikki, at this point, we're talking about the vacation before September 19th, before Gabby's body is found. There's no prosecution to hinder. So, for all of you asking, but if they knew he killed her, isn't that harboring a fugitive? No, he's not a fugitive. He wasn't arrested. He didn't have a warrant out for him. He's not a fugitive. So you can't be prosecuted for harboring a fugitive when he doesn't have a warrant out for his arrest and they're not harboring anyone. That's getting into like Minority Report territory of like, well, we're going to find out later that you did it, and then we're going to back it up and say you're harboring a fugitive even though no one's looking for him. That's not how the law works. So no. And this is where, again, it's important to talk about the morality, legality, because a lot of you are like, I hate this, that this is the result, but it's also the law. No warrant issued. He's not running from the law. Nobody's looking for him, and they're not obligated to tell the police to go look for him. So legality and morality are different, right? So Mary P said, wasn't Brian Laundrie being evasive with law enforcement? Not at this point. At this point, law enforcement wasn't looking for him. We are in the time period up to September 19th. So Q&A is going to be real busy today. So some of you hold on to those questions. Let's keep going. Well, Gabby Petito's family was suffering. The Laundrie family went on vacation. And again, this is morally reprehensible behavior. It doesn't mean they are legally liable or criminally liable for morally reprehensible behavior. And I will just say, I don't cover politics, but a lot of the political fights that we see in our country are people fighting over morality that I generally don't think should be legislated. So when we're talking about legislating morality, the side I fall down on is, I don't know if we want to make things that you morally don't like a crime or not legal. Like that can be a very, very slippery slope. So when we're looking at the law, trying to say, okay, well, you can only get married in this type of relationship. To me, that's trying to legislate a morality. I don't like that. I don't like legislating morality. Let people live their life. So when you start legislating morality, then you get the option of whose morality are we legislating? And a lot of us fall down on different sides of that, right? So this comes into the where do we legislate like what a decent person would do and who gets to decide what decent is, and do we want our laws legislating somebody's morality, and whose morality do you choose? And that's not my morality, so I don't necessarily want you telling me what I can do. So this gets in, when we're talking about this case, we have to also look at, in this circumstance, I think a lot of you are like, this is gross. I hate this behavior. I hate that they're not required to do anything. But please try to look at it on the flip side of that and say, but what circumstances do I see people trying to legislate their own morality that is not mine? And then you see where a lot of these fights come in with legislating morality. Steve C says, except this is about murder. It's not, though, Steve. Right now, we're not talking about murder. We're talking about words. Right now, we're talking about what the Laundrie parents are allowed to or not allowed to do. Brian Laundrie shouldn't have murdered anybody. But we're not talking about Brian Laundrie murdering Gabby Petito. He can't be prosecuted for that. He's deceased. We're talking about whether the parents of an adult who knew that their son killed somebody were obligated to say something. That's different. But I understand why it's frustrating, but we're not talking about it. Question from Miss Bananas. If you are told by someone that they killed someone, are we obligated to report that? Generally, no. But there are some circumstances, yes. So it's very much going to depend on the circumstance. So instead of going on with general, we're going to just talk about this situation. So, how are laws made? Well, Jenny, how laws are made is by people voting for people and those people writing laws. So again, if the people of Florida are like, this is fucked, the people of Florida can vote for people and be like, hey, we want there to be a snitch law. We want people to be required to say something. I don't know if that's the way we want to go, folks. But Blue Coffee Cancer Girl said, but they did say something. We're going to get there. We're not there yet. We're not there yet. Harlot said, aren't we obligated not to harbor someone we know is a murderer? It's not obstruction of justice because no one is looking for him. It's not harboring a fugitive because there is no warrant out for him. So right now, they have a reasonable belief that he killed his fiance, but there's nothing legally happening yet that would preclude them from saying, get the fuck out of our house. There is maybe a moral obligation, but is there a legal obligation at this point? No. I don't see a legal obligation at this point. So let's continue on. Marianne said, thank you for covering this. I love these types of discussions that are intelligent and non-screamy. I think it rubs a lot of us the wrong way in our feelings. The behavior feels reprehensible. But we have to look at what the facts are. So, and a lot of you guys have a lot of questions. David said, should have been a warrant, the cop's fault. David, I would just ask, how is it the cop's fault before she's been found? We're still in the time period before Gabby Petito has been found. And law enforcement in Florida can't get a warrant for him. There's not a crime that happened in Florida that they know of. So it's hard. What should the warrant have been for prior to them finding her? Which is why missing persons is so difficult. Because without finding her, how do you have legal probable cause to go arrest Brian Laundrie? You can't go arrest Brian Laundrie saying this is sus. So that girl T says, why is it a moral obligation if they didn't know? At this point, we know that they know. So at this point, we know that they know. Um, Smurf Anna said at this point she's a missing person, and we all know missing adults isn't always a priority. Missing adults have some difficulties that are different than missing children. And a lot of those are privacy concerns. This is a whole conversation for probably another day, but with missing adults, it takes law enforcement time to be able to get into somebody's cell phone, right? Because if the situation was that Gabby Petito ran from a abusive relationship, if that were the situation and law enforcement was trying to get into her phone to track her or find where she is, how much time needs to pass to allow law enforcement into her phone in a way that it's not a violation of her Fourth Amendment rights against searches and seizures? At what point, and there is generally a waiting period to make sure somebody isn't willfully missing, which happens in abuse cases where people leave and do not want to be found. That's not what happened here, but it can happen. But it takes time for law enforcement to have probable cause to get into an adult's phone. It is very difficult because sometimes people choose to leave and not be found. That can happen. So if somebody is missing, it takes time for law enforcement to be able to get into their phone, which is very frustrating. I will just say, with your families, with your adult children, with your friends, set up a system so that somebody is a trusted person that has access to your location. Because if somebody has my phone location access, they can access that. But law enforcement can't access that. And that is tremendously frustrating. But we don't want law enforcement being able to willy-nilly go get into somebody's phone. It's like, oh, somebody said they were missing 12 hours ago, especially when you look at it in the context of potentially abusive relationships. You don't want somebody who may be an abuser to go to law enforcement and be like, hey, I haven't seen my girlfriend in 12 hours. I need you to get into their phone and tell me where they are. Can you see how badly that could go? So there are a lot of different conversations here and a lot of reasons that law enforcement can't just break into an adult's phone and go find their location. But it is frustrating, right? Okay. Let's continue on. Into this complaint. We got to the vacation, which again feels gross, but is there anything legally wrong that they did here? No. In an effort to avoid any contact with Gabby's mother, on or about September 10th, Roberta Laundrie blocked Gabby's mother on her cell phone such that neither phone calls nor texts could be delivered, and she blocked her on Facebook. Again, I don't like this at all. But are you allowed to put somebody on block? Yes. So does this go into causing emotional distress? I'm trying not to say emotional damage because it is a serious case, but is this going towards the intentional infliction of emotional distress? On September 13th, the date Brian Laundrie left his home, according to a televised interview with Steve Bertilino, on or about October 23rd, 2021, Brian Laundrie was grieving. That is an awkwardly written sentence. But on October 23rd, Stephen Bertilino gave an interview saying that on September 13th, Brian Laundrie had left and was grieving. So now the evidence that they are alleging in this complaint, the third complaint, says that Brian Laundrie, as of September 13th, was grieving. That Brian called his parents on September 1st, frantic, said that Gabby was gone and he needed an attorney. They got a criminal defense attorney and they contacted the public defender's office in the county where Gabby Petito's body was eventually recovered. Those are things leading to believe that they knew more than just that Gabby Petito was gone, right? So on September 13th, Brian Laundrie left home and was quote unquote grieving. According to the Cambridge English Dictionary, grieving is defined as feeling sad because someone has died. So this is evidence that they are alleging leads you to believe that Stephen Bertilino, the attorney, knew that Gabby Petito was deceased, that Brian Laundrie knew Gabby Petito was deceased, and that gone went beyond missing. That gone meant gone from this plane of existence. All of this to lead up to say that when the Laundries made a statement to the media, they knew that Gabby had been killed. So that's the foundation they're building here. And B2 makes a very good point in the chat. One can grieve the loss of a relationship. True. And if the defense are arguing, and they might, that what Brian reported to them is that Gabby was gone, that their relationship was over, and that he was grieving the loss of his fiance and that their relationship was over, that might be their argument. I don't know how a jury's going to buy that. But they might. It is an argument. On September 14th, with full knowledge that Gabby Petito had been murdered by Brian Laundrie, it's believed that they knew the whereabouts of her body, Stephen Bertilino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. Quote, "This is understandably an extremely difficult time for both the Petito family and the Laundrie family. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. On the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment." That statement is a statement to the media, not law enforcement. And that statement is the heart of the IIED, NIED claims here. Is that statement extreme and outrageous and causing harm to the Petitos? This is a great question, Muhair. So why did he need a lawyer for a breakup? And that's the counter argument, right? Why get a criminal defense attorney if you're grieving the loss of a relationship? If your fiance has left you and you still have their van and their wallet and their bank cards, why do you need a criminal defense attorney? So, that statement is the crux of this question. For the Laundries and Bertilino to express their, quote, hope that Petito was located and reunited with her family at a time when they knew she had been murdered by Brian Laundrie was beyond outrageous. This language goes to the intentional infliction of emotional distress. Stephen Bertilino, at the time he issued the September 14th statement, was aware that Joseph Petito resided in Florida and that the statement was intended to reach Joseph Petito. Goes to jurisdiction. On September 14th, the statement released by Bertilino was intended to be disseminated nationwide, and it was, and was broadcast in news reports in Florida and nationwide, and was disseminated electronically to Florida jurisdiction. On October 13th, 2021, the interview was conducted with a reporter at WABC Channel 7 in Sarasota. At all times relevant to the within cause of action, Bertilino has sufficient minimal contacts with the state of Florida. This goes to jurisdiction. In that he was acting as an agent for the Laundries, who are residents of Florida, and released numerous other statements regarding the Laundries to national press and into Florida in particular. He was communicating quite frequently with JB from WFLA, Florida, and Brian Entin, who was with WFLA at that time in Florida as well. At all times relevant to the cause of action, Bertilino engaged in substantial, not isolated activity in Florida. That goes to jurisdiction. On September 16th, attorney Richard Stafford, on behalf of the Petitos, issued a letter to the Laundries as follows, quote, "We are writing this letter to ask that you help find our beautiful daughter. This is 3 days before she's found. We understand that you are going through a difficult time and your instinct to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat and our lives are falling apart. Don't doubt any of this is true. I'm saving a comment that I want to get to right after I read this. We believe you know the location of where Brian left Gabby. And it seems that they were not wrong, because at this time, Brian had already called them, asked for a lawyer, and they had hired lawyers in Wyoming. We believe you know the location of where Brian left Gabby. We beg you to tell us. As a parent, how could you let us go through this pain and not help us? As a parent, how can you put Gabby's younger brothers and sisters through this? Gabby lived with you for over a year. She was going to be your daughter-in-law. How can you both keep her location hidden? You were both at Jim and Nicole's house. You were both so happy that Brian and Gabby got engaged and were planning to spend their lives together. Please, if you or your family have any decency left, please tell us where Gabby is located. Tell us if we are even looking in the right place. You can tell how much pain they are in. We know this. We knew this from watching this case unfold while they were searching for Gabby Petito. It goes on to finish. All we want is Gabby to come home. Please help us make that happen. Despite the fact that the defendants knew that Gabby was deceased, knew where her body was located, and expressed their quote-unquote hope that Gabby would be quote-unquote reunited with her family, the Laundries and Bertilino refused to respond to either Joseph Petito or Nicole Schmidt. While the Petito parents were desperately searching for information concerning their daughter, the Laundries and Bertilino were keeping the whereabouts of Brian Laundrie secret. Petito's remains were discovered on September 19th in the Bridger-Teton National Forest in Wyoming. On the same day, Bertilino issued a statement saying, quote, "The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family." They should have said nothing. Or they shouldn't have blocked the Petitos. There's a lot of shoulds here. That's probably not helpful to go to the shoulds. There's a lot of shoulds here. The Laundries and Bertilino knew of the mental suffering and anguish that the Petito Schmidts were experiencing in not knowing the well-being or location of their daughter. That's an awkward way to put that sentence. And further knew that such mental suffering and anguish increased each day that Gabby was missing. This all goes to the causes of action that we'll get to. While the Laundries and the attorney remained silent about Gabby's death at the hands of Brian Laundrie and the location of her body, all while knowing she was deceased and knowing the proximate location of her body, they chose to issue statements on September 14th and September 19th. In issuing the statements, the Laundries and Bertilino engaged in conduct. This is the law part. Engaged in conduct which was intentional or reckless, that they knew or should have known that the statements would cause emotional distress, and knew or should have known that the Petito Schmidts would suffer emotional distress from the statements. That is the heart of this case. In issuing those statements, were they intentional or reckless in causing further emotional distress to Gabby Petito's parents? If they had said nothing, issued no statements, or if their statement had been, hey, the Laundrie family has no statement at this time, this case would not have been brought. This case is only brought because they made those statements. Because you cannot force someone to act or to make a statement where they have no obligation to do so. And there is no legal obligation here to do so. Is there a moral obligation? I feel that there probably is. But that's my own morality. But that's not a legal obligation to say something. So, it goes on to say, the Laundries and Bertilino exhibited conduct which was outrageous and went beyond all bounds of decency. This goes to the law. and is regarded as odious and utterly intolerable in a civilized community. And this is where there is room for the morality part of this. The jury will get to decide what is utterly intolerable in a civilized society. And they will get to decide whether or not this behavior is intolerable. Does it go beyond all bounds of decency? And is it outrageous? Keeping in mind that there is case law in Florida that grieving families can suffer additional distress on top of the grief. Because, of course, the Laundries attorneys will argue at some point that the Petitos were suffering because their daughter was missing, that the extreme emotion and anguish was not regarding the statement, but was regarding the fact that their daughter was missing. That's what they will argue. And that might go to damages, but to get to liability, was this behavior intentional or reckless? Because both are charged. Should they have known that these statements would cause more damage or emotional distress? And is the behavior, the statements, outrageous and beyond all bounds of decency? And I think there are going to be some that would say that this statement is outrageous, but I think there are others that are going to say that this statement is not outrageous. This statement is a statement saying, we hope that they're reunited. So I think there is going to be a lot of discord on this. If we get to a trial, we still have to go through summary judgment. But could some jurors say that giving the family false hope is absolutely intolerable, and they should have known that they were giving the family false hope, and they should have known that that would cause damage? And the only way to make that argument is to prove that they knew that she was dead. And I think that they've been able to prove that they knew that Gabby Petito was dead. If they can't prove at this point that they know that Gabby Petito is dead, then it's very hard to prove that they know it could have caused extreme and outrageous injury. It could have caused more distress. But I think we've gotten to the fact that they knew because Brian Laundrie called them and said, Gabby is gone. I need a criminal defense attorney. So this puts the Laundries in a position where they are going to have to argue that the word reunited, and they've argued this in motions. If you've watched the other motion hearings we've done, they argued that the word reunited does not necessarily mean reunited alive. I would never want to be the lawyer making that argument to a jury. Would you? Well, when we made the statement, we hoped that they found her. We hoped that the search was successful and that she was reunited. But we meant that we hoped that they would uncover her remains. That's not an argument you want to have to make to a jury, because they're going to be like, are you kidding me? Because a family that is searching for their missing daughter, when you say we hope the search is successful, successful does not indicate that she is deceased. That's not a successful search. I don't want to ever be the lawyer arguing that a successful search means her remains are recovered. This is not a good argument to fly with a jury if this gets to a jury. But this is the argument they made at the motion to dismiss. That reunited can indicate remains just as well as reunited could indicate someone who is alive. The Laundries are not in a great position to argue this if this goes to a jury. I think the Laundries are going to be fighting like hell at motion to summary judgment to have this not go be in front of a jury. Because every argument they have to make in front of a jury is bad. Because I think there's room to argue under the law that was the behavior reckless? I think you can argue it's reckless. Maybe you think it's intentional. I think there's room to argue. I think there's room to argue that they would have known the statements would cause emotional distress. The fact that they blocked them, knew that they didn't want to hear from them. I think there's a lot of room to argue they knew that that would cause emotional distress and that they would suffer as a result of that. And I think there's room to argue that the behavior is utterly intolerable in a civilized society. I'm seeing that from the chat. There's over 10,000 of you here. And most of you are like, I don't know if it's illegal, but I sure fucking hate it. And that's, I think, where a jury's going to get to. I don't know what they did, but I hate it. I hate this. And I understand. All right, let's go through the counts. Count 1. As a direct or proximate result of the intentional, what is on my lip? Of the intentional or reckless conduct of Christopher Laundrie, Joseph Petito has been caused to suffer pain and suffering, mental anguish, inconvenience, loss of capacity for enjoyment of life, experienced in the past and to be experienced in the future, which emotional distress was severe. So this is why there are multiple counts. This is Joseph Petito, Gabby Petito's father, suing Brian Laundrie's father. The next cause of action is Gabby's father suing Roberta Laundrie. Same thing. So it is plaintiff versus individual defendant over each plaintiff. Nicole Schmidt, Gabby Petito's mother, suing Christopher Laundrie, Roberta Laundrie, and Stephen Bertilino. So that's how we get to all 6 counts, because we have one cause of action by 2 plaintiffs covering 3 defendants. Does that make sense? So these are all IIED. 1 count each for each plaintiff, 1 count each for each defendant. Does that make sense? Hopefully that makes sense. I know you guys have a lot of questions, but we are not done yet. There's a lot more information we need, and we are going to go through each of it. But what pleading it like this does is it allows a jury to potentially find the Laundries liable and not find Bertilino liable, depending on what facts come out. If Roberta Laundrie got the phone call, but Christopher Laundrie didn't, and he didn't quite know what was going on, and Roberta was the one doing all the talking, it allows for the jury to kind of pick and choose. Emma Mack asked, are these criminal or civil? This is a civil case. I love Pie said, but it's all one case. Yes. Jules Smith said, so they're suing each other. No. Gabby Petito's parents are each suing Brian Laundrie's mother, father, and lawyer. Gabby Petito's mom is suing Brian Laundrie's mother, father, and lawyer. Gabby Petito's dad is suing Brian Laundrie's mother, father, and lawyer. 2 plaintiffs, 3 defendants, 1 cause of action by each person. So that is the 3rd amended complaint. What we are going to talk about now is what's going to come up for hearing on the 20th, which is the motion to compel further testimony of Stephen Bertilino. Let's switch to this. Motion to compel the testimony of Stephen Bertilino. Stephen Bertilino being the attorney. The motion to compel we're going to get into. The depositions are ongoing. So this is saying we did a deposition. We need more information. We need the court to give us more information. This was filed on October 26th. Motion to compel testimony of Stephen Bertilino from the plaintiffs. A significant component of plaintiffs' complaint in this matter is the defendants, including Stephen Bertilino, were aware that Gabby Petito, the daughter of the plaintiffs, was deceased and knew the location of her body at the time a statement was issued by the defendants on September 14th, in which the defendants expressed their hope that Petito would be reunited with her family. So this is why I did the 3rd amended complaint first, so the cause of action is in our mind. I'm saving these questions. The depositions of the defendants, Christopher and Roberta, took place on October 10th and October 11th, respectively. At the depositions, it is not often we get to know what happened at deposition until we get to trial. At the depositions, Christopher and Roberta Laundrie waived attorney-client privilege between themselves and Stephen Bertilino. I find this shocking. I'm going to put up a poll, and I'm going to cross my fingers that the polls are working. Please cross your fingers with me that the polls are working. I find this shocking. Here's the poll. Are you surprised at the Laundries waived? All right. Are you surprised? Emily spells surprised right. That the Laundries waived attorney-client privilege. I'm starting the poll. If you cannot see the poll, it seems to be a known issue. I am working on it. We are going to talk about Brian Laundrie separate from his parents in this. We're talking just about the parents. But I am very surprised. If it's established that the Laundries were clients, they could have said we didn't. They could have asserted attorney-client privilege. They would have to prove that they were clients of Stephen Bertilino. They could have asserted attorney-client privilege and not said any of this. I think it's very interesting. Again, if they were clients, which I still have questions about, because the client might have been Brian Laundrie and not Christopher and Roberta Laundrie, they may not have had attorney-client privilege. So I am assuming that Christopher and Roberta Laundrie were in fact clients of Stephen Bertilino. That is the base assumption I am making, that they are clients. If they're not clients, then there would be motions like this arguing that they're not clients and that they have to say what they told Stephen Bertilino because there's no attorney-client privilege there. And there would have been motions arguing it. Instead, we're just going to see motions arguing that Stephen Bertilino, well, we're in that motion now. So if the Laundries had asserted privilege, they would have had to prove that the privilege applies, and there would be hearings going through that. I'm not sure that the Laundries were actually clients of Stephen Bertilino. I am very surprised that they waived attorney-client privilege. It might just be because no privilege existed and they didn't want to go through the litigation. But I am surprised they did not throw up legal roadblocks here that are valid legal roadblocks. Maybe it wasn't a valid legal roadblock and they waived privilege because no privilege existed. Possible. Very possible. But I am surprised that they willingly waived and didn't make the court make a finding on it. I am surprised by that. They could have said none of this. So I am surprised that they waived that privilege between them and Stephen Bertilino. I am very surprised by that. So Doc TJB said, if they weren't clients, there's no privilege to waive. I agree. But it doesn't mean if they weren't clients, they could make the court make a finding because they were having what could be considered privileged conversations with Stephen Bertilino. It is gray as to this area because they have worked with him in the past. They could have argued that the phone calls they were making to him for help, they assumed that he was their lawyer. So, and they're arguing, the plaintiffs in this case are arguing that they were clients. So the Petito family is arguing that they were clients and that Stephen Bertilino is their agent. Like this, the Petitos are kind of in a pickle here because, let me see if I can explain myself better. I feel like I'm not explaining myself well. Hold on. The Petitos in their lawsuit are arguing that they can sue the Laundries over something Stephen Bertilino said because Stephen Bertilino was their lawyer. So I've got two trains of thoughts on separate tracks going this way, and I'm trying to rein them back in. So the heart of the lawsuit with these statements is that Bertilino was acting on behalf of the Laundries, which is why they're not just suing Stephen Bertilino, they're suing Bertilino and the Laundries. So they are saying, we know you were clients of Stephen Bertilino. Bertilino could have said, they're not my clients, you can't sue me. Or the Laundries could have said, we're not his clients, just sue him. But instead, we're here with the Petitos saying that the Laundries were clients of Stephen Bertilino, and Stephen Bertolino's statements are as an agent to them, which means they could have gone to their deposition and said, anything we told Stephen Bertilino is privileged, and we are not sharing it. Well, again, that might have been distasteful. It would have been legally proper. So they chose to be forthcoming in their depositions, and they could have asserted attorney-client privilege, it seems. And it seems that because nobody's challenged the fact that Bertilino was acting as an agent. Everybody's just like, yep. So they could have asserted attorney-client privilege and chose to waive it, and that is very interesting. So let's get back into this motion to compel. The Laundries chose to waive attorney-client privilege at their deposition. I am shocked. I am shocked. During his deposition, Christopher Laundrie, and we get to know what's at the depositions, which is rare for us. I'm excited. Christopher Laundrie testified that he spoke with Brian Laundrie on August 29th, 2021, that Brian Laundrie was frantic, stated that Gabby Petito was quote unquote gone, and asked his father to get him a lawyer. Imagine that testimony before a jury, given these circumstances. Defendant Christopher Laundrie further testified that he advised Stephen Bertilino of this conversation. If this survives summary judgment, I will be shocked if they don't settle. I don't think it'll settle before summary judgment, but who knows? I'll be surprised if this case goes to trial. The deposition of the defendant, Stephen Bertilino, was taken on October 17th. During Stephen Bertilino's deposition, he testified that Christopher Laundrie did advise him on or about August 29th, and that he spoke with Christopher Laundrie, dad, advised lawyer, that he spoke to Brian on August 29th, and that Brian was frantic and stated Gabby Petito was gone and requested his parents obtain a lawyer. During Bertilino's deposition, he asserted attorney-client privilege with regard to conversations with Brian Laundrie and refused to disclose any information he learned from Brian Laundrie about Gabby Petito's well-being or last location. That is the point of this motion. This motion to compel is because Bertilino is asserting attorney-client privilege as to Brian Laundrie, who is deceased. Yes, attorney-client privilege survives one of the parties being deceased. It doesn't just go away. And Brian Laundrie's not here to waive it. And Stephen Bertilino, I don't think, can waive it. So now we have to have a very long conversation about attorney-client privilege and whether or not Brian Laundrie was the client or whether his parents were the client, and at what point Brian Laundrie became the client. Florida Code 90.5022 provides that a client has privilege to refuse to disclose and to prevent any other person from disclosing the contents of confidential communications when such other person learned of the communications because they were made in the rendition of a legal service to the client. Statute 90.507 provides that a person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person voluntarily discloses or makes the communication when he does not have a reasonable expectation of privacy or consents to disclosure of any significant part of the matter of the communication. So this is when it's when you see people going, oh, my lawyer told me blah, 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 blah. You're like, don't be out here saying what your lawyer said. You're going to waive your privilege. Brian Laundrie, it goes on to say, murdered Gabby Petito on or about August 27th in the Grand Teton National Forest in Wyoming. Her body was not discovered until September 19th. Brian Laundrie committed suicide on or about October 20th. Following the discovery of his body, a notebook was discovered in his backpack in which he conferred? Okay, now I'm pissed. Look, some of these typos I get. I am a typo queen. Look. But when we are talking about a confession to murder, can we not? I'm just saying, can we not? I might be being too harsh, chat. You let me know if I'm being too harsh. He conferred to murdering Gabby Petito. Confessed. He confessed. He confessed. Am I being a dick about this? He confessed to murdering Gabby Petito. A true and correct copy of such letter marked Exhibit A is attached. It is? It is. I didn't know that was here. Oh, the whole letter's here. I don't know how much we're going to be able to read, chat, because some of it's in cursive, but the whole letter's here. The whole confession letter from the backpack is here. Oh. Did I know that was here? No, I didn't know that was here. I don't know if we've ever seen the entire letter. Have we ever seen has the entire letter ever been made public? Miguelina, will you let the rest of the app crew know that we're going to go over the whole letter? We're going to read the whole thing. We've never read it on this channel. I don't know if it's been Melissa in the chat asked, why can't we read cursive? Because I'm dyslexic. So sometimes cursive is difficult. The letter has been made public. I've not read it on this channel. We're going to read it now. Why can't we read cursive? That's why. Okay. I wasn't sure if the entire letter had been made public. I know contents of the letter had been made public, but we're going through it. We're going through Brian Laundrie's confession letter in a minute. Okay. Wait, I got distracted. Where was I? Oh, conferred to murder. That's where we were. A true and correct copy of such letter is marked Exhibit A is attached. T. Because Brian Laundrie confessed, there it is, confessed. Because Brian Laundrie confessed to the murder of Gabby Petito, the conversation he had with Stephen Bertilino about such murder is no longer protected by the attorney-client privilege as it has been waived by the client. I don't know about that. I don't know if that works. Rotten Ralph, yeah, we went over, wait, my chat jumped. We went over his mother's burn after reading letter. I have not gone over this letter. I have seen reports of what's in this letter. I don't think I've seen photocopies of this letter. It might be out there. I have not seen it. Let's continue. So the argument is, because Brian Laundrie confessed to the murder, attorney-client privilege no longer exists. I don't know if I agree with that, but let's continue on. Clearly, Brian Laundrie had no expectation of privacy in authorizing a confession. I mean, it seems like he penned it, and leaving it in his backpack to be found following his death. Case law, St. Paul Fire and Marine versus Welsh. Attorney-client privilege waived with respect to letter which client voluntarily produced. Well, the letter is not privileged, but the conversation with the lawyer might still be. It is black letter law that once the privilege is waived and the horse is out of the barn, it cannot be reinvoked. Hamilton versus Hamilton. I guess the horse is out of the barn is a more elegant way of saying the shit is out of the horse, but I don't know. I'm not 100% on board with this. We're going to have to read the letter and see if he really waived attorney-client privilege. We're going to have a very long time going over attorney-client privilege. What does black letter law mean? So behind me, hold on, I'm coming. I'll be back. I've not gone far. Ukulele's in my way. All right. My understanding of black letter law comes from this. This is my copy of Black's Law Dictionary. I believe this is what they're referencing, but here's what black letter law generally means. But I believe it is a reference to Black's Law Dictionary. Black letter law generally means it is well settled law. If that is not the etymology of black letters law, then I don't know what it is. But it has always been my understanding that it comes from like the settled law, like it is known law, like this is the way. Black letter law equals this is the way. It is settled law. So they are saying it is irrefutable law. That's what they are saying. So, Black's Law Dictionary. I need an updated one. This is the 7th edition. I wonder what edition they're on now. I kind of like having my one from law school. I wish I had saved some of my other law school books. When I went to the DA's office, I yeeted a whole bunch of them. I was like, torts. Yeet. Like, I'm never doing tort law again. Fuck, get this shit out of here. I kept my criminal law books because I was like, I'm never going back to anything that is remotely civil. Haha. And then when I left the DA's office and was moving, I was like, I don't need these books from law school. Like, who still needs their books from law school? Me desperately wishing I still had my fucking books from law school doing this. And I have reordered some of them. Damn it. Because I had this was not a plan. Emily, did you plan to be a legal analyst on the internet? Nope. I yeeted all of my books. It's the only thing. Normally when I purge things, I was like, this does not bring joy. Get the fuck out. I'm normally thrilled. This I regret. It is the only thing I've yeeted that I regret. Okay. Let us continue. Black's Law Dictionary. Let us go. Yes, it's basically Mandalorian law. That's where it is. Alrighty. Oh, Alicia. Yeah, my husband still has almost like every journal of prosthetic dentistry that it was ever published. I was just like, I don't need it. Regrets. No regrets. Okay. It is black letter law that once privilege is waived, the horse is out of the barn. It cannot be reinvoked. From Hamilton and Hamilton. Since Brian Laundrie has waived the attorney-client privilege based upon the confession he made in a letter, Stephen Bertilino cannot assert attorney-client privilege and refuse to answer questions about what Brian Laundrie told him concerning the murder of Gabby Petito. I'm not sure we're there. I have questions. I'm not on board all the way yet. Even were the attorney-client privilege not waived by Brian Laundrie, yes, please give me the arguendo, because now I got questions. Florida Statute 90.5023E provides that a lawyer can only raise attorney-client privilege on behalf of the client. The lawyer may not assert the privilege on his behalf. That is a better argument. Although, and this is coming from Rogers versus State, although Mr. White has standing to raise the lawyer-client privilege, in the case the privilege is possessed by the client. And the argument here should be, that you can't protect Brian Laundrie from anything because Brian Laundrie is deceased. So there is no client left to protect because there are no rights left to be damaged. Here's following through on that argument. Brian Laundrie's been sued civilly. That civil suit has settled. There is no outstanding liability for him. There is no criminal liability for him. There's nothing else that can happen. So there's nothing else to protect him on. Different than like an attorney who does wills and trusts. There are potential legal implications after somebody passes in a wills and trust circumstance where an attorney would not waive that privilege at all because you're still protecting the interests of the client after death. So they're arguing that Bertilino's trying to protect himself and not trying to protect Brian Laundrie. So, in the within matter, it says Bertilino was not asserting the attorney-client privilege on behalf of Brian, who has already waived the privilege. I have questions. But rather, he is asserting it on his own behalf in an effort to keep himself from testifying about what he knew at the time he made the September 14th statement. Because the attorney-client privilege was waived by Brian Laundrie in his confession, and because Stephen Bertilino could not raise the privilege on his own behalf, Bertilino must be ordered to testify concerning conversations he had with Brian Laundrie regarding the murder of Gabby Petito and the location of her body. Let's get to this letter, shall we? Oh boy. Okay. This is the photocopy of the confession that I have not before seen. So let's take a swoop real quick. Emily. Wrong swoop. I need to zoom this out a little bit. Gabby, I wish I was just warning. This is probably going to piss me off. This letter is written to Gabby after he killed her. All right. Gabby, I wish I was right at your side. I wish I could be talking to you right now. I am going to read this without giving commentary, and it is going to be a struggle for me. I am going to read this without giving commentary, and it is going to be a struggle for me. Okay. I wish I could be talking to you right now. I'd be going through every memory we made, getting even more excited, I think that says, for the future. Um, the way this makes dyslexia difficult. Talking to you right now, I'd be going through every memory we made, getting even more excited for the future. But we lost our future. I can't live without you. Something every day. This sentence, something every day something spent together, every holiday. I'll never go to something with, I don't know what that is either. Again, never go hiking with TJ. I loved you more than anything. Sorry, this is taking me a minute. I can't begin to look at our photos, or I can't bear to look at our photos. So you're going to see me actively turning my head. I would turn the paper if I had it, but I can't. I can't begin to look at our photos to recall great times, because it is why I cannot go on. When I close my eyes, I will think of laughing on the roof of the van, falling asleep to the sight of a meteor shower at the Crystal Geyser. I will always love you. Sir. If you were reading something journal, looking at photos from our life together, flipping through old cards, you wouldn't want to live a day without her. Are we talking to someone else? It seems like this is now talking to someone else. If you were reading Gab's journal, maybe he's talking about her journal. Looking at photos from our life together, flipping through old cards, you wouldn't want to live a day without her. Knowing that every day you'll wake up without her, you wouldn't want to wake up. I'm sorry to everyone this will affect. Gabby was the love of my life, but I know something by many. I'm so very sorry to her family, because I love them. I'd something her younger siblings. Oh, I consider her younger siblings my best of friends. Really? I am sorry to my family. This is a shock to them as well, a terrible grief. Oh, this is a difficult photocopy. Remember, this did get wet. But yes, to the chat that's saying, why do these look different? I don't know. I don't know. All right. So let's see. They loved us so much, if not more than, I think he's talking about his family, if not more than a new daughter to my mother, an aunt to my nephew. Please do not make this harder for them. This something is an unexpected tragedy. Something back to our car trying to cross the stream of Spread Creek before it got too dark to see, too cold. I hear a splash and a scream. I could barely see. I couldn't find her for a moment. Shouted her name. I found her breathing horribly, gasping. She was freezing cold. She splashed into the water for a minute and had a high. No commentary. No commentary. No commentary. No comment. No commentary. I found her breathing horribly, gasping. She was freezing cold. I can't read the rest of this. Something National Park. In Utah, the temperature had dropped to freezing and she was soaking wet. I carried her as far as I could down the stream towards the car. Something exhausted in shock when my knees, I think that says buckled, and knew I couldn't safely carry her. I started a fire and spooned her as close to the heat. She was so thin, had already been freezing too long. I couldn't at the time realize that I should have started a fire first, but I wanted to get her out of the cold, back to the car. From where I started the fire, I had no idea how far the car might be, only knew it was across the creek. When I pulled Gabby out of the water, she couldn't tell me what was hurt. She had a small bump on her forehead that everything got larger. Her feet hurt, her wrist hurt, but she was freezing, shaking violently. While carrying her, she continuously made sounds of pain. That looks like laughing, but I can't tell. Um, she said something lapsing between violent shakes, gasping in pain, begging for an end to her pain. Sir? She would fall asleep and I would shake her awake, fearing she shouldn't close her eyes if she had a concussion. She would wake in pain, start her start her pain cycle again, while furious that I don't know if that's furious, that I was the one waking her. She wouldn't let me try to cross the creek. I thought he pulled her out of the creek on the other side. Thought, like me, I can't read that part, would go out on her sleep and she'd freeze. I don't know the extent of Gabby's injuries, only that she was in pain. I ended her life. I thought it was merciful. That it is what she wanted, but I see now all the mistakes I made. Murder. Murder is the murder. Okay. But I see now all the mistakes I made. I was in shock. But from the moment I decided, took away her pain, I couldn't go on without her, or I decided I couldn't go on without her. Oh, there is a transcript of the letter. Thanks, Megalina. We'll get to the transcript next. We'll get to the transcript next. It'll be better. I rushed home to spend any time I had left with my family. So he decided he couldn't go on without her. I rushed home to spend any time I had left with my family. I wanted to drive north and let James or TJ kill me, but I wouldn't want them to spend time in jail over my mistake. Though I'm sure they would have. I am ending my life not because of fear of punishment, but rather because I can't stand to live another day without her. I've lost our future together, every moment we could have shared. I'm sorry for everyone's loss. Please do not make life harder for my family. Sir. They lost a son and a daughter, the most wonderful girl in the world. Gabby, I'm sorry. I have killed myself by this creek in hopes that animals may tear me apart, that it may make some of her family happy. Please pick up all of my things. Gabby hated people who litter. Okay. So, that is the confession / suicide note or burden shifting. Here's the thing that we need to focus on. This may or may not actually deal with attorney-client privilege. And that's the purpose of this letter and the photocopies of this letter being contained within this motion is whether or not Brian Laundrie waived his attorney-client privilege with Stephen Bertilino in writing this letter. And well, he makes up this whole story, and I remember when this became public, when he makes up this whole story that because I don't believe the autopsy supported this, when he talks about the accident, the freezing, the fact that he is noble and he couldn't do anything but take her out of her pain, and then he couldn't live without her, so he had to take himself out of his pain. I don't know if that is going to get to the point where he has waived his conversation with Stephen Bertilino. It might not. It might not at all. So this letter is coming. This letter is written after he left his house, after her body is found, and after the intense media pressure and scrutiny with regard to this case. And after, I believe, because it's real close in time to when that warrant went out, because the warrant went out and then it was discovered that he was missing. Those things happened very close in time. So the things were closing in, and it's very interesting that he said, I am not doing this to escape punishment. I'm doing this because I can't live without her. However, if this had been an accident and if she had gotten hurt, there are other options. Those are all arguments for another day. Either way, the autopsy is pretty clear on what happened here. And it's this letter is very much giving, I did what I had to do, which is a very interesting circumstance where he's like, I can't live without her. I love her. I did what I had to do. That doesn't necessarily relate back to the autopsy, but we're not here to debate the murder of Gabby Petito. We are here to decide if this letter, or at least have a conversation about whether this letter opened up the door to attorney-client privilege. And I'm trying to focus on that fact. And we are trying to focus on did he open up the door to attorney-client privilege? So with that, we need to go to the response from Stephen Bertilino to talk about the attorney-client privilege and not whether or not Brian Laundrie murdered Gabby Petito, because he confessed to murdering Gabby Petito. The circumstances as he lays them out versus the circumstances as many believe them to be might be different. But for all purposes today, we need to go through this motion to compel. So let's go through Bertilino's response to the motion to compel. Remember, what we are in the middle of is a motion to compel Stephen Bertilino to testify about what Brian Laundrie told him. So in that context, we need to look at Stephen Bertilino's response to the motion to compel, because we have read through the letter. If I need to go to the transcript, I will. We have read through the letter. I don't know if there's anything in the letter that completely opens the door to attorney-client privilege. And that's what we need to talk about now. So, and trying to focus on that is hard because it's like, I have so many thoughts. Defendant Stephen Bertilino's response to plaintiff's motion to compel the testimony of Stephen Bertilino. Comes now, defendant, pursuant to law. On October 17th, plaintiffs deposed Mr. Bertilino. Bertilino was upfront and candid in responding to the questions put forth at the deposition, and the deposition was not limited by time or restriction in any way. Interesting. While some questions posed to Bertilino were objectionable, the only questions which he was unable to answer sought attorney-client communications between Bertilino and Brian Laundrie. Even then, to the extent the question could be answered with non-privileged information, an answer was given. At no point was it advanced or suggested by plaintiff's counsel that Brian Laundrie had waived attorney-client privilege with Bertilino, or the assertion of attorney-client privilege was inappropriate or disingenuous. So they're like, yo, none of y'all said any of this. None of y'all said any of this when I was doing the deposition. So why is it coming up now? Following Bertilino's deposition without any citation to the transcript, which was not ordered by plaintiff's counsel. Oh, interesting. He's like, y'all didn't even order a transcript. And without a basis in law or fact, plaintiffs filed the instant motion. This is going to be an interesting court hearing, isn't it? Specifically, plaintiffs seek to compel the disclosure of confidential communications exchanged between Brian Laundrie and an individual requesting legal services. Did he or did his dad, though? Did he? Plaintiffs seek to compel the disclosure of confidential communications exchanged between Brian Laundrie, an individual requesting legal services, and Mr. Bertilino, a licensed attorney. The basis for plaintiff's request is the existence of a private journal maintained by Brian Laundrie that was recovered by law enforcement after Laundrie's death and contains his own version of events that transpired between him and Gabby Petito, which ultimately led to her demise or murder. Plaintiffs argue the content of the journal entry, which in no way describes, documents, or otherwise discloses communications Brian Laundrie had with his attorney, not wrong, or the legal advice given, also not wrong, somehow constitutes a carte blanche waiver of any and all privileges which would apply to Brian Laundrie's confidential communications with Bertilino regarding Petito's death. Plaintiffs also incorrectly argued that the privilege is raised on Bertilino's behalf, not Laundrie's, without providing any record citation to support his claim. Plaintiff's motion is procedurally non-compliant, Emily words, substantively non-meritorious. Good God. Plaintiffs set forth arguments that, if accepted by this court, would severely compromise the attorney-client privilege that exists between countless clients and their chosen legal counsel. Probably true. Probably true. Ashley asked a great question in the chat. But he wasn't licensed in Florida or Wyoming, correct? He could not have represented Brian in any case, right? So you can hire lawyers to consult with your case and work on your case from any jurisdiction. And those lawyers can bring in local counsel in the jurisdiction they're in to also work with them. And then you can also enter into court pro hoc vice and represent a client in a different jurisdiction. So could Bertilino have represented him? He could have worked on his case with local counsel. Yes, he could have. But it doesn't mean that he would have been the one standing in court arguing it, but he could still do it. When we looked at the Toddy Westbrook, all the Toddy Westbrook cases, we look at Salty's law firm as a California law firm. But in the Washington case, there was also a Washington law firm, and they were pro hoc vice. In the Nevada cases, there's also a Nevada law firm. So yes, you can have, in theory, a New York attorney working with your Wyoming attorneys on a case. So yes, it can happen. And Bertilino, I don't think, is a criminal attorney either. But you can still have that lawyer work with you, especially if it's, which seems to be the case with Bertilino, a longtime family attorney that he's trusted. It goes on to say, let's see. Nope, I went too far. Plaintiffs argue that the content of the journal entry, I'm just going to repeat myself for a minute, which in no way describes, documents, or otherwise discloses communications Brian Laundrie had with his attorney, Mr. Bertilino, or the legal advice given, somehow constitutes a carte blanche waiver of any and all privileges which would apply to Laundrie's confidential communications with Bertilino regarding Petito's death. Plaintiffs also incorrectly argue the privilege is raised on Bertilino's behalf, not Laundrie's, without providing any citations. Plaintiffs, there we go. Procedurally non-compliant, substantively non-meritorious. Plaintiffs set forth arguments that, if accepted by this court, would severely compromise attorney-client privilege. The motion does not identify a single question that was inappropriately objected to or provided a basis for why that objection should be overruled. Without hesitancy, it's a great sentence. Without hesitancy, the motion is due to be denied. Procedural noncompliance. As a preliminary issue, plaintiffs have wholly failed to comply with the 12th Judicial Court Local Rule 5 addressing discovery matters. Local Rule 5 expressly requires movement to confer with counsel for the opposition before filing a motion to compel in a good faith effort to resolve the issues. Wait, you didn't meet and confer? You got to do a meet and confer. Like in most jurisdictions, you have to do a meet and confer for this. Plaintiff's motion is devoid of any such certification, and absolutely no meet and confer efforts were undertaken by plaintiffs. For this reason alone, the motion should be denied. Beyond the meet and confer requirement, plaintiffs also violated Local Rule 5B, which requires a movement to quote in full each question on deposition to which the motion to compel is addressed and the objection and the grounds for given by the opposing party. Yes. Yes. I don't disagree with any of that. You have to say, I asked question A, and they objected on the basis of attorney-client privilege. This is a very fair point. Where is question this was not asked. So to quote in full each question on deposition, this is consistent with the Florida law mandating that courts evaluate each objection asserted before any potential privilege or confidential materials may be compelled. That might happen at hearing, which will be interesting. Within the motion, plaintiffs do not cite a single deposition question, that's true, that was objected to, which plaintiffs believe should be answered for the reasons set forth in their motion. Without compliance to Local Rule 5B, the court is deprived of the opportunity to meaningfully evaluate the impact of plaintiff's motion and the appropriateness of the objections raised. Instead, the court is forced to consider plaintiff's motion in a vacuum without understanding what specific questions are truly at issue based upon questions asked and objected to at Bertilino's deposition taken October 17th, 2023. Footnote 1. The total number of questions asked at Mr. Bertilino's deposition and objected to on attorney-client privilege grounds is likely less than 10. I mean, if the question is, what did Brian Laundrie tell you, though, that can cover a lot of grounds. Additionally, to the extent plaintiff's motion is intended to compel Bertilino to testify in response to questions that were not asked during his October 17th, 2023 deposition, plaintiff's motion seeks improper relief. Plaintiff's failure to comply with Local Rule 5B provides another independent procedural basis to deny the motion. Substantive deficiencies. Miss Fitness 3 said the Petitos won the civil lawsuit. Yes, no. No, we're in the middle of it. That's what we're doing. That's all of this. We're in the middle of the civil lawsuit. So no, they did not win. We are a long way from done. Substantive deficiencies. Separate and apart from procedural deficiencies, plaintiff's motion is materially deficient and is premised upon flawed logic. The writing is definitely snappier by the defense. And is premised on flawed logic, incomplete derogation. I don't know if I've ever seen derogation in a filing. Incomplete derogation of well-established law protecting and preserving the sanctity of attorney-client privilege, even after the death of a client. As explained below, the attorney-client privilege absolutely applies to the confidential communications exchanged between Brian Laundrie and his attorney, wherein Brian Laundrie was expressly seeking legal advice and guidance from Bertilino. Brian Laundrie in no way waived his attorney-client privilege by privately journaling his thoughts and impressions of the events that transpired between him and Gabby Petito, and the privilege applies posthumously. Mr. Bertilino appropriately raised the privilege on behalf of his deceased client, as he is legally and ethically obligated to do. The only thing I will say to that is that I don't know if this was actually a private journal that was uncovered. The journal entries are written and seem to be written with no expectation of privacy, because the journal entry is written saying, essentially, this is my note. I know I'm going to die. I know this is going to be public. It seems written in the context of knowing that the note would become public. So I don't think it is the same as a private journal entry that not every, that was a private journal entry that was never meant for anyone else's eyes. I think this was written in the context of knowing others would read it. And in fact, written one to Gabby and then one to the public, I think, and one to his family. Because he said in that letter repeatedly, don't hold this against my family. I think that was written not as a journal entry, but to the public. It was a suicide note. He knew people were going to read it. So I disagree with the fact that it is a private journal entry, but I don't disagree that the journal entry or the letter or the note discussed attorney-client conversations, and he gave his version of the events of what happened as he wanted people to see them. And that doesn't unwind the conversations between him and his lawyer, though. Robin in the chat asked, sorry, but how did Brian die again? A self-inflicted gunshot wound in a large park in Florida. I think this was intended to be publicly read, but it doesn't talk anything about his conversations with his attorney. I think this is a difficult hurdle. I think the attorney-client privilege with regard to Brian Laundrie is a difficult legal hurdle. I don't think this is an easy win for the Petitos. Applicable law. A trial court possesses broad discretion in overseeing discovery and protecting the parties that come before it. As part of that discretion, trial courts often must consider issues of privilege, including attorney-client privilege, which Florida courts recognize, quote, plays an essential role in the adversary system. Yes. Yes, it does. The attorney-client privilege is the oldest confidential communication at common law, and it is traditionally deemed worthy of maximum legal protection. The attorney-client privilege's purpose is to encourage full and frank communication between attorneys and their clients, and thereby promote broader public interest in the observance of law and administrative. That can't be right. I think it's administration of justice. The privilege recognizes that sound legal advice or advocacy seeks public ends, and that such advice or advocacy depends upon the lawyers being fully informed by the client. The privilege rests on the need for the advocate and counselor to know all that relates to the client's reasons for seeking representation in the professional mission, for seeking representation of the professional mission is to be carried out, or if the professional mission is to be carried out. I agree. You can't adequately and ethically represent a client. I don't know if ethically is the right word. You cannot adequately represent a client as a zealous advocate if you don't know everything. When clients hide things, the lawyer is at a significant disadvantage. The privilege comes into existence and has been protected assiduously since to serve the important purposes of encouraging clients to disclose their circumstance fully to lawyers. That's why it exists. And oftentimes they will find attorney-client privilege where lawyers don't even think they have a relationship with somebody. And the courts will lean towards finding privilege there and finding a relationship there where even the lawyer is like, I didn't think there was a relationship there. Lawyers have to be very mindful of not giving legal advice, of not giving legal advice at a cocktail party or whatever, because you can absolutely end up in a circumstance where a lawyer doesn't think they have a attorney-client relationship and the client thinks they do. And generally that errs to the side of the person who thinks they do. But it depends on the circumstance. So undue hardship is not an exception, nor is disclosure permitted because the opposing parties claim the privilege information is necessary to prove their case. Doesn't matter if it's privilege, you don't get it. The attorney-client privilege is codified by statute, which states, quote, a client has a privilege to refuse to disclose and to prevent any other person from disclosing the contents of confidential communications when such other person learned of the communications because they were made in the rendition of legal services to the client. Furthermore, the statute makes clear that privilege may be claimed by the lawyer on behalf of the client. As recognized by the highest court in our nation, quote, it has been generally, if not universally, accepted for well over a century that the attorney-client privilege survives the death of a client. Yes. Finding privilege precluded disclosure of information conveyed to attorney by client who committed suicide shortly thereafter. I've already said it like 3 times. YouTube's going to hate it. We just continue to go on. Indeed, the United States Supreme Court has concluded that there are weighty reasons that counsel in favor of posthumous, I said that's so weird, application of the privilege, and it serves much broader purposes than simply protecting against self-incrimination. Communications between lawyers and their clients are prima facie attorney-client privilege when communications appear privileged on their face. The party seeking disclosure bears the burden of proving they are not. The Petito family must prove that these are not communications. And I don't think the motion saying he wrote a letter that was found next to his body is going to get them there. Acknowledging private conversations between attorneys and their clients are generally protected by privilege, and finding it was appropriate for the trial court to preclude party from eliciting testimony from attorney regarding confidential communications. The attorney-client privilege is inviolate as to matters within its scope, and waiver of the privilege is not favored in Florida. Because the privilege belongs to and protects the client, a fortiori, we've got all the legal words today. A fortiori, it is only the client who can waive the privilege. Citing case law, recent case law from 2022, finding no waiver based on attorney conduct and quashing subpoena requiring attorney to submit a deposition. To satisfy the initial burden, the party asserting the waiver must establish the client relinquished any right to maintain confidentiality of the communication. And again, I don't think the letter with the alternative set of, or Laundrie's set of circumstances, plus an apology, didn't address anything that he talked about with his lawyer. So admitting to killing Gabby Petito in the letter doesn't address, like, my lawyer told me not to write this letter, or my lawyer said this or that. It doesn't waive the privilege. Florida statute 2023 addressing the waiver of a privileged communications offers guidance. A person who has a privilege against the disclosure of a confidential matter or communication waives the privilege if the person voluntarily discloses or makes the communication when he or she does not have a reasonable expectation of privacy. Going on the internet and saying, my attorneys told me not to sing it, might waive an attorney-client privilege. Maybe. My attorneys told me blah, blah, blah. You might be able to get to the heart of that communication. Oh, so did you advise your client not to say anything? Maybe. But I don't think that letter gets to voluntary disclosure. So voluntarily discloses the communication when he or she does not have a reasonable expectation of privacy. So that can also be, this came up in Murdaugh a little bit. If Murdaugh is in a room of 15 people talking to one person about Maggie and Paul, is that communication privileged? Well, no. There's no expectation of privacy, even if the person you're talking to is your lawyer. If you're having a conversation about your case with your lawyer in front of 10 people, there's no expectation of privacy and you waived that privilege. If you and your lawyer are having a one-on-one conversation, it's different. To show a clear intentional waiver of privilege, the factual basis of the waiver must include disclosure of the actual communications exchanged between the lawyer and the client. My lawyer said this, this, and that. And I don't think the letter includes a disclosure of the actual communications. The letter says nothing about what the lawyer happens. Shishudo said, but why would the lawyer refrain from telling them what happened? Because he's legally obligated not to. He can't disclose what his client said to him. Now, if they can prove that Brian Laundrie wasn't a client, then it's different. But they haven't shown that Brian Laundrie wasn't a client. If they can show Brian Laundrie wasn't a client, then that's different. But assuming that Brian Laundrie is a client, Stephen Bertilino cannot disclose the contents of those communications at all. It's not been waived. And the court's going to have to find it's been waived. And I don't think on this, the court's going to find that it's been waived. Because nothing in that letter is discussing the communications with the lawyer. Waiver does not occur until there has been an actual disclosure of the confidential communication, which would be the client saying, my lawyer and I talked about A, B, C, D, E, F, G. My lawyer said this. I said this. I told them this. They advised me this. It has to be a disclosure of the communication. You have to disclose the conversation that you had with the lawyer or the email. Like putting an email between you and your lawyer on Twitter in a screenshot would waive attorney-client privilege, right? Forwarding an email between you and your lawyer to other parties could also do that because now there's no expectation of privacy because you forwarded it to third parties. But I don't think the note, the meant for the public note does that. I just don't think that it does. What do you guys think? Here, let me end this poll. Are you surprised that the Laundries waived attorney-client privilege? 86% yes, 14% no. Okay. I'm going to ask another poll. For some of you, you might not be able to see it. I'm sorry. We're trying to fix the bug. Do you think the note included the attorney-client communication? Yes or no? So the poll is, do you think the note included the attorney-client communication? Yes or no? Let's continue. Most illustrative of the question of waiver raised here is State v. Schmidt, 1985. In Schmidt, the court concluded that a criminal defendant's written confession where he admitted to murdering the victim and his subsequent deposition testimony regarding the same did not constitute a waiver of attorney-client privilege, and therefore the attorney appropriately refused to testify regarding same. That seems pretty on point. Absent clear evidence of waiver by the client, the attorney is legally and ethically obligated to maintain the client's confidences, and failing to do so, the attorney may face liability. Facts. Attorney may be liable for disclosing privileged communications even after representation concluded. The end of the representation of a client or the end of the client's life does not end the attorney-client privilege. The solemn duties of fidelity and protecting confidences begin when the attorney-client relationship is first formed and continue to the end of the case and sometimes even beyond. Footnote 2. Both the Florida and New York rules of professional conduct prohibit a lawyer from knowingly revealing confidential information gained during or related to the representation of a client. And that's exactly what's being sought here. Plaintiffs did not dispute the existence of the attorney-client relationship. All right, let's continue on from footnote 2. Understanding this duty and the importance of promoting the public policy which underpins the privilege, courts have routinely precluded parties from eliciting testimony from attorneys regarding matters protected by privilege. Existence of privilege. In the instant case, it is obvious that the communications which are the subject of plaintiff's motion fall squarely within the definition of attorney-client privilege communications. Was Brian Laundrie a client then? You're saying yes. I don't think anybody's proved it. Emily. Footnote 3. Read footnote 3. Footnote 3. Plaintiffs do not dispute the existence of the attorney-client relationship or the concomitant privilege, but rather take the position that the privilege is waived. So they said, look, everyone agrees that Brian Laundrie was a client of Stephen Bertilino. Nobody's arguing he's not a client. They're just saying he waived the privilege. I don't think he did. All right. Existence of privilege. We did that. In the instant case, it's obvious that the communications which are subject to the plaintiff's motion fall squarely within the definition of attorney-client privilege communications. Specifically, plaintiffs asked the court to compel Bertilino, quote, to testify concerning conversations he had with his client, Brian Laundrie, regarding the regarding the murder of Gabby Petito and the location of her body. It is undisputed that an attorney-client relationship existed between Bertilino and Laundrie, and that a confidential conversation occurred between them on September 1st, wherein Brian Laundrie sought legal advice. However, attorney Bertilino did go on the news and say that Brian Laundrie was grieving. Is that him sharing the content of a communication? Or is that him sharing a perception of a mental state? Because Bertilino talked about his conversation with Brian Laundrie in the media. But Brian Laundrie didn't. These communications are prima facie attorney-client privilege, means on the face of it, it just is. Privilege is not waived. Unable to challenge the existence of the attorney-client privilege, they didn't challenge that at all. Unable to challenge the existence of the attorney-client privilege, plaintiffs have attempted to manufacture a basis for waiver by citing Laundrie's personal journal entry that documented in his private notebook found near his dead body, where Laundrie recorded his own version of events that transpired between him and Petito, which ultimately led to her demise. This discovered journal entry and others were viewed by law enforcement personnel in connection with their investigation into the death of Brian Laundrie and Gabby Petito. Plaintiffs argue that Brian Laundrie's discovered confessions eviscerates all privileges which attach to the confidential communications Laundrie may have had with his attorney concerning the same. As a starting point, the cases cited by plaintiffs in favor of waiver are inapposite. In St. Paul versus Welsh, no privilege objections were raised before certain privilege documents were voluntarily produced to the client's adversary by the client, and therefore the privilege was waived. Yeah, that doesn't track. That clearly doesn't track. Here, privilege has been raised by Mr. Bertilino on behalf of Brian Laundrie with no voluntary disclosure of the confidential communications exchanged between them. In Hamilton versus Hamilton, confidential information was announced by the attorney in open court, and then a dispute arose between the attorney and the client. I imagine so. There, the court deemed the privilege was inapplicable because the communication was relevant to an issue of breach of duty by the lawyer to his client, and because the confidential information was disclosed in open court. Yeah, that's a circumstance where the attorney fucked up. And here, it's not been argued that Bertilino somehow fucked up and waived the privilege in his statement about Brian Laundrie grieving. They didn't even bring it up. Here, there has been no pronouncement of the privileged communications exchange between Bertilino and Brian Laundrie to this court or anyone else. Bertilino's client has not raised any argument that Bertilino breached any duties owed to him. Mia asked, what about doctors? I am not a doctor. I am not an expert in medical. The privilege there can be different, but there are privileges there. Brittany asked, would privilege be waived because he left the note in the middle of nowhere? And I can't see that having an expectation of privacy. Brittany, the contents of the note don't discuss the conversations with the lawyer. So the content of the note is an issue here because the content of the note does not talk about any communications with the attorney. Let's see. For a waiver to occur, it is imperative that a client's actions clearly demonstrate an intention to disclose confidential information shared with the attorney and relinquish any right to maintain the confidentiality associated therewith. Again, back to my example of a client going on Twitter and being like, my lawyer told me this, so fuck you. Like, my lawyer told me we're going to win because I told my lawyer this and they told me this. That is the client disclosing that to the broad internet. But this is not the client's actions never talked about communications with the lawyer. Here, a careful reading of the contents of Laundrie's journal found near his body reveals absolutely no confidential communications between Brian Laundrie and his lawyer. I don't disagree. There is no mention of Bertilino or any other lawyer, and Brian Laundrie in no way divulges the content of any privileged conversations he had with his attorney. Because Brian Laundrie's journal entry, which according to plaintiffs purportedly provides a basis for waiver, does not describe specific communications. That is the standard. Specific communications he had with his lawyer, there can be no waiver. However, even if, we're at arguendo. Even if the journal entry did divulge the content of privileged communications, Brian Laundrie had with Bertilino, which it does not, to find a waiver, plaintiffs would have to prove that Brian Laundrie voluntarily disclosed attorney-client privilege information or made the communication when he did not have a reasonable expectation of privacy. Here, there is absolutely no evidence to suggest Laundrie intended for anyone to read the contents of his personal journal entry. Disagree. I agree with a lot of this. I disagree to that. Blue Coffee Cancer Girl said, if the note was addressed to Gabby, why is attorney-client privilege an issue? Attorney-client privilege is an issue because the Petitos are seeking to gain information about the conversation Brian Laundrie had with Stephen Bertilino. The note is not privileged. The note's not privileged. What's in the note's not privileged. The Petitos are arguing that the note waived attorney-client privilege, not that the note is privileged. So the note's not a problem, but I don't think the note's a waiver. Hopefully that answers the question and makes sense. Plaintiffs would have to prove that Brian Laundrie voluntarily disclosed attorney-client privileged information and made the communication when he did not have a reasonable expectation of privacy. Again, I don't think the journal is privileged. I don't think the journal is private. I don't think the journal was made to be a private communication. But I also don't think the journal is a waiver of attorney-client communications. Right? Here, there is absolutely no evidence to suggest Brian Laundrie intended for anyone to read the contents of his personal journal entry. Res ipsa loquitur. I think the journal speaks for itself. I think the journal was written for others to read. I disagree. I understand their argument. I disagree. But even though I disagree, I don't think it changes the nature of the argument. If that makes sense. I think he meant for it to be public. I think he meant to try to paint himself in a different light in the public. I think he meant to get the public to leave his family alone. I think that was absolutely made for public consumption, knowing that there would be public consumption. But I don't think it waives communications. And I think the arguendo is, even if he wrote this, he wrote it to kind of clear his family's name and put his name in a better light post-death. I don't think it did that, but I think that might have been the intent there. But I can disagree with this point, but it still doesn't change the legal standing of the argument. It continues to argue, even though the content of the journal was revealed by the posthumous discovery thereof, posthumous. I can't read it right. I know how to pronounce it, but I can't read it right. Without the ability to ask Brian Laundrie himself, we can never know if he genuinely expected his most personal thoughts documented in his journal would be made public. I appreciate your advocacy, counsel, let alone if he meant to knowingly and voluntarily waive the privilege. That part I don't think he did. The journal was found by law enforcement with Brian Laundrie's body. Was it found by law enforcement or was it found by his family? Because they found some of it. The journal was found by law enforcement with Brian Laundrie's body in the Carlton Reserve, and as a result, the contents of the journal were made known. Laundrie did not voluntarily publish the contents of his journal and thereby voluntarily waive privilege. He didn't talk about his lawyer at all in the letter. And it's very possible Laundrie believed the journal would be lost in the woods with him and never found. He asked his parents to pick up his trash, sir. I appreciate your advocacy. And its contents never be known. Without clear evidence of Brian Laundrie's intention to reveal the substance of his confidential attorney-client communications, which are not set forth or otherwise described within his journal, plaintiffs cannot satisfy their burden of proving Brian Laundrie waived his privilege here. I don't disagree. Privilege properly invoked. Pursuant to section 90.5023E Florida statutes, the attorney may raise the attorney-client privilege on behalf of the client. In fact, if an attorney does not uphold their duty to maintain client confidences by asserting the privilege on the client's behalf, they may face liability. Facts. C. Eklund, acknowledging duty of confidentiality constituted a legal duty of an attorney to a client long before it was included in the ethical rules, and its inclusion as an ethical rule did not thereby eliminate the tort. Plaintiffs incorrectly suggest Bertilino is asserting the privilege on his own behalf and ignoring the broader purpose served by the application of the attorney-client privilege, which are acknowledged by the United States Supreme Court in Swindler. Don't. Swindler, not swindler. It's not a case about lawyers called Swindler, Emily. Stop it. Swindler in Berlin. Mr. Bertilino is ethically and legally obligated to raise the privilege on Laundrie's behalf to protect Brian Laundrie's interests, which continue to exist posthumously. Damn it! You get to watch the ADHD happen in real time today, folks. I mean, maybe it's not just today. Posthumously. Clients may be concerned about the reputation, civil liability, or possible harm to family and friends, and posthumous disclosure of such communications may be feared as disclosure during the client's lifetime. It raises the issue of, and I've seen a number of you say in the chat or ask in the chat, because lawyers are smart and you ask great questions, but what interest is left to protect? This case law envisions that there are still interests left to protect. Raising the privilege here on the behalf of Brian Laundrie serves and protects Laundrie's interests. Bertilino, as Laundrie's attorney, is obligated to protect those interests, and that duty exists regardless of public hostility or personal distaste for the offense or the client. He should have stated that, I think, at the beginning. It is a very fair statement. The legal duty rises above, and our system envisioned it that way, so that even the most disdained or distasteful defendant has rights that are protected by them, protected by the Constitution, and that their lawyers protect them. And the job of a lawyer is to protect even the most disdained defendant when those things come up. Everyone has those rights, no matter the public hostility, even though sometimes that is hard. And I get that. Lawyers put the heart aside and are like, my job. Thus, the privilege was appropriately raised by Bertilino on Laundrie's behalf. Public policy considerations. Do we need the public policy considerations? I mean, it's a fair point. The ramifications here are tremendous. Under plaintiff's theory, at any time a criminal defendant voluntarily or involuntarily makes an admission of guilt known to the public, even if through the act of pleading guilty, the attorney-client privilege would cease to exist, and the criminal defendant's attorney must then divulge the entirety of the attorney's communication with their client on that topic. This is a very fair point. They're taking the slippery slope argument and saying, look, if the court starts overturning attorney-client privilege conversations because a client confessed to a crime in a note, does that extend to a client pleading guilty? Does that extend to a client pleading guilty under a no contest or an Alford plea? Where does that end? And there's times that a client may plead guilty and a case may not still be all the way resolved, and people would sue that criminal defendant civilly to try to get to this information and break attorney-client privilege to find where money was hidden, where property was hidden, where a body was hidden, whatever. And so they're saying just because somebody says that they are guilty doesn't violate attorney-client privilege. It's a good argument. Such a result would jeopardize the trust and confidence that underpin attorney-client relationships, and our entire system, and would neuter the good use of the word neuter, and would neuter the fundamental principles promoted by the attorney-client privilege, our oldest confidential communication traditionally deemed worthy of, quote, maximum legal protection. Even unpopular clients must be free to disclose all pertinent information to their attorneys. Our system is really set up to protect the least popular defendants, right? That's the point of the Constitution, to protect those that might not otherwise be protected. Plaintiff's position in this regard is fundamentally at odds with the entire body of law that values and protects attorney-client privilege. Moreover, to suggest that someone who decides to privately write down some version of events that has led them to commit suicide somehow intended and knowingly and voluntarily waive their attorney-client privilege through this act is preposterous. Well, we know they have strong feelings about it. This is especially true given the confession contains zero mention of the substance of communications exchanged between Bertilino and Laundrie. It's fair. To find waiver under these circumstances would introduce substantial uncertainty into application of the privilege with severe public policy implications. Upholding the attorney-client privilege is not just a matter of individual rights, but also as a societal imperative. Confidentiality fosters honesty, allowing attorneys to provide informed and accurate advice. When clients fear that their communications may be forcibly disclosed, even posthumously, they are less likely to seek legal guidance, potentially leading to uninformed decisions, legal complications, and unjust outcomes. Conclusions. Plaintiffs have provided no basis in fact or law to justify the extraordinary relief sought. Procedurally, plaintiffs have not complied with Local Rule 5. Plaintiffs fail to cite a single specific question that was inappropriately objected to or adequately explain why the objection should be overruled. The absolute privilege unequivocally applies to the communications at issue. Plaintiffs have failed to satisfy their burden to prove Brian Laundrie voluntarily waived his attorney-client privilege, which continues to exist after his death. Granting plaintiffs' motions would not only infringe upon Laundrie's rights, which have been appropriately asserted by Bertilino on Brian Laundrie's behalf, but would also severely compromise the attorney-client privilege, which is at the core of our legal system. I don't disagree. I don't disagree. I understand they might want to get those communications. I am still surprised that Brian Laundrie's parents waived their attorney-client privilege with Stephen Bertilino to answer questions. But I don't think Bertilino can waive this privilege, and I don't think the court can make them. It is a good argument. I took issue with very little in their argument, except I don't think that the letter was meant to be private, but it is to the side of the heart of this issue. So let's summarize this real quick and then get to your questions. There's a lot of questions. I know you guys have a lot of questions on this. This is not an easy case to walk through because the emotional component is so strong. The distaste for the Laundrie's behavior is so strong. It is a difficult one. Oh, wait, there's an interview we need to get to. Hold on. Let's do the interview and then get to Q&A. We're almost 3 hours in. It's fine. Some of you go subscribe. It'll be worth it. Let's do that real quick. Let's do the interview. I'm not going to do the transcript of the letter because I don't think there's anything in the letter that's going to waive privilege. But Miguelina, will you put the transcript in the description so we'll have one that's available for y'all? Because I want to get to the interview and then get to the questions. I think that's fair. Let's do a quick summary. Thank you, Miguelina. Let's do a quick summary. All right. The motions that we have gone through today over attorney-client privilege revolve around Gabby Petito's parents seeking the court to compel or force Stephen Bertilino to disclose conversations he had with his client, Brian Laundrie. They cite back to the note that Laundrie wrote to Petito and I think for public consumption right before his death, that acknowledged that he was taking his own life, that gave his version of what happened with Gabby Petito and admitted to killing her, and asked for essentially everyone to be kind to his family and to apologize to her family and to his family. Gabby Petito's lawyer has said that that letter confessing to the murder waived the attorney-client privilege. Therefore, the court should force Stephen Bertilino to answer the questions that they have that were objected to during his deposition. Bertolino's attorneys are arguing, look, that letter does not waive attorney-client privilege. It doesn't discuss anything that was specifically discussed with the lawyer. It talks nothing about the attorney-client privilege. And so therefore, the motion should be denied, and Stephen Bertilino cannot be forced by the court to answer those questions that are covered by attorney-client privilege. That is the heart of that motion. We also went through the third amended complaint, which contains a lot more information. I think they're getting ready for summary judgment motions, but contains more information about what the Laundries knew and when. And that contained much new information about what the Laundries knew and when. That the Laundrie family and Stephen Bertilino had calls with Brian Laundrie, that the Laundrie family told Stephen Bertilino that they had a call with Brian Laundrie, that he was frantic. He said that Gabby Petito was quote unquote gone and that he needed a lawyer. Stephen Bertolino's actions were then to hire a criminal defense attorney in Wyoming and to contact the public defender's office in the county in Wyoming where Gabby Petito's body was ultimately found. The Petitos want to argue that Stephen Bertilino and the Laundries knew at the time they put out their statement hoping for finding Gabby Petito and that she would be reunited with her family, that they knew at that time not only that she was deceased, but where her body was. And they are using that information to prove that when they made the statement, they knew where Gabby Petito was and that she was deceased, which goes all the way into whether those statements were negligent or intentional, whether they were outrageous, whether the Petitos knew, whether the Laundries knew that it would cause the Petitos extreme emotional distress. So that is where we're at today. We are going to go to the interview with the family attorney for the Petitos that was recently on News Nation. It's about a 5-minute segment with Brian Entin that I wanted to go to and cover now. Hold on, let me pause that. I'm going to make sure we've got the sound turned up real quick, and then we will go real quickly to that interview and talk about that real quick because it will give us just a little bit more information before we finish this up. Again, this case is going back into court at the end of the month, and I will cover that court hearing here on the channel because I'm interested. And I think y'all are interested. Pretty sure y'all are interested. All right. Let me do this. Where are we? There we are. All right. Let us continue.
Loud is Patrick Riley. He is the attorney for the Petito family. Pat, we appreciate you being here. You know, I thought I knew the ins and outs of this case, but, you know, my jaw dropped when this new information came out really over the weekend.
Very surprising.
Involving what you allege the Laundries knew and when they knew it. Basically saying that...
I understand that Brian Entin is saying when you allege what the Laundries knew, this is coming from deposition. So yes, it's made in allegations in the third amended complaint and in the motion to compel, but it is coming from their deposition. This is what they said in their deposition. So while it's alleged, the statements are their testimony will be. I mean, it's not alleged that they knew it. It's now they've testified to knowing it.
About 2 weeks before Gabby Petito was reported missing, that Brian Laundrie had made a phone call to his parents saying that Gabby was, quote, gone, and that he needed a lawyer. How were you able to discover this, Pat?
Well, good evening, Brian. Thank you for the
Deposition.
invitation this evening. The deposition of Christopher Laundrie and Roberta Laundrie was taken back in October, as well as attorney Stephen Bertilino. And during that deposition, for the first time, Christopher Laundrie disclosed that on August 29th of 2021, he received what he called a frantic telephone call from Brian, in which Brian disclosed to him that Gabby was gone and that he needed a lawyer. So that just confirmed what we had suspected going back almost 2 years.
So I'm thinking back to that time, Pat, and there is this search happening all over the country for Gabby Petito, an enormous amount of police resources all over the place. Everybody's looking for her. And according to this new information that you're presenting, the Laundries knew that she was gone. And I know this is now a civil trial, but I think a lot of people are watching this wondering, like, how is this not criminal if they didn't come
I know a lot of people are asking, oh, that's
forward with that information?
that's kind of a dirty pause there. You guys are asking that in the chat and asking it repeatedly. Why wasn't this a criminal case? I'm very interested to see what Pat Riley has to say here. But when we get to Q&A, I will be talking about it again because I've seen so many questions, and I know during a longer live stream you guys come in and out. A lot of questions. Why isn't this a criminal case? So I'm interested to see what Pat Riley has to say about it, or if he's just going to say, well, that's up to law enforcement.
I mean, were they allowed to withhold that?
Well, I'm not a criminal lawyer, but I know that attorney Bertilino.
I'm not a criminal lawyer. Nope. He is noping out of this, which, because he is the lawyer for the Petitos, he is not here in this interview as a legal commentator or a legal analyst. It's fair that he nopes out of that question, I think.
Bertilino has certainly taken the position that they had the right to remain silent. They don't have an obligation to disclose. So I don't know whether or not there are any possible criminal charges that could be brought against them at this point. But certainly in terms of the civil litigation, this is very big information for us.
Yeah, and
this is the information I believe that the Petitos were looking for getting this case to discovery. They wanted to know what this family knew and wanted to know what their son had told them. And it is incredibly disheartening and disturbing to hear that their son called, said, you know, my fiance is gone. He was frantic. He needed a criminal attorney. Where he needed a criminal attorney, that he took her van and her, you know, wallet and whatever, went back to his family home, and then they took him on vacation. Like, you know, it's very, very disheartening. But that doesn't mean that they had a liability or a obligation or responsibility to report what their son had said to them in a phone call, right? So different thought processes, but for the civil case, this is the information they needed. They needed to be able to prove at trial what the Laundries knew and when, and now they can. They know, the Laundries know that she is gone. And could the Laundries try to get up on the stand and be like, well, we weren't sure quite what our son meant, but we got him a criminal lawyer anyway? Come on. You called the public defender's office, not because you're worried that they broke up, right? Because you're worried that there's going to be a criminal case. That's why you get a criminal attorney. So they're not going to be able to easily argue that they didn't know what gone meant in this context when he was frantic. You know, it's like when you watch The Real Housewives of New Jersey, some of you may, and Teresa Giudice is like, well, when we went away. You didn't go away, you went to prison. But people use colloquial vernacular that's kind of understood. And I don't think they're going to be able to prove to a jury that they didn't know when the statement was made that they didn't know that Gabby Petito was deceased. This is the information they needed. If this case survives summary judgment motion, this is what they need for the jury. And if it survives summary judgment motion, I wouldn't be surprised if it settles, but what is it going to settle for? I don't think the Petitos want money. I think they want to know. I think they want the truth.
Laundries, again, this all came out as part of the new
And probably an apology.
filing, collected a $25,000 retainer to pay a law firm in Wyoming. Yet at the same time, they were going public through their attorney at that time, releasing statements. There was one statement that said in part, on behalf of the Laundrie family, it is our hope.
I'm going to back this up real quick because we're going to talk about this retainer when we get to Q&A.
Big information for us.
Yeah, and the Laundries, again, this all came out as part of the new filing, collected a $25,000 retainer to pay a law firm in Wyoming. Yet at the same time, they were going public through their attorney at that time, releasing statements. There was one statement that said in part, on behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That was September.
So this is the actionable statement in the civil litigation. But the fact that there was a $25,000 retainer put down, that is quite a large retainer. That is a large retainer to put down for a criminal defense attorney. But they put down a $25,000 retainer for a criminal defense attorney, which indicates to me at that time, they were not necessarily believing that Brian Laundrie would escape prosecution in some way, right? That is a substantial retainer. I don't know what the typical legal fees are in Wyoming, but that's a substantial retainer for large markets, LA, New York. So that is, it indicates to me that they knew that this was going to be a substantial case if there was a criminal case and they were anticipating it.
November 14th. August 29th is when you're alleging that he was told she was gone, that they needed a lawyer. So are the statements really a big part of the case here? I mean, were they intentionally trying to mislead people, do you think?
Well, the statement certainly is the focal point of this particular case. It's really the only cause of action we could bring against Christopher and Roberta Laundrie.
Yes.
And the import of the statements is it supports our allegation that at the time that they made the statement, hoping that Gabby would be reunited with her family, which to most people, I believe would mean that she's going to be alive and it's going to be a happy reunion. At the time they made that particular statement, they knew that she was deceased, and they had known that for about 2 weeks and kept quiet for that 2-week period, despite the pleas from the family to help find her. And they chose to speak up and make that particular statement with knowledge that she was already deceased.
Are you surprised, Pat, that Chris and Roberta Laundrie were so forthcoming with this information? Because couldn't they have said, look,
I am. I know Brian's not asking me this question, but Brian, I am absolutely surprised that the Laundries were so forthcoming in their depositions. Absolutely surprised. Absolutely surprised. Yep.
Attorney-client privilege, we don't have to tell you what was going on behind the scenes in terms of us talking with lawyers and that kind of thing?
Well, it was an attorney-client privilege for what Brian told them. There's no privilege there. What they may have told Attorney Bertilino could have been privileged, but they waived the attorney-client privilege in terms of their relationship with Attorney Bertilino.
Very surprised.
So how do things play out? I mean, I know there's a trial date set, the civil trial for next year. Is there any chance of a settlement? I would imagine, I mean, the Laundries don't want more information like this coming out. Would you consider a settlement?
We would consider a settlement, but it would have to be under the right terms, and no one has proposed proper terms or right terms for the family at this particular point in time.
What are those terms? Are we going to find out what these terms are? I would like to know what they would want from a settlement, which is probably information to be made public.
But a settlement is always a possibility.
Interesting. Okay. Well, Mr. Riley, we'll continue to follow the case. Thank you for coming on. We appreciate it.
And I think that if we are going to see a settlement, I should finish this interview, but I think if we are going to see a settlement, it'll be after the motions for summary judgment are done. That would be my guess, is when you're most likely to see a settlement. Let's see if there's anything else here.
Thank you, Brian.
Thanks so much for watching.
Nope. There we go. Emily, just give it 3 more seconds and you would have been done. So I think we're going to get through the motion for summary judgment first, because if the motion for summary judgment is granted, then the case is over. If it's denied, then the case moves forward. And instead of going to trial, it gives room for there to be a settlement. But I don't think I don't know. It'll be interesting to see, but there is a hearing for this case on the 20th. I will be covering that hearing as live as we can. So let's get to your questions. You have so many of them about this case, and I understand some. I'm not going to answer every single one because a lot of them are on the same topic, and sometimes it feels like you don't like the answer. I understand. I'm going to give a soliloquy. We're going to give a soliloquy in just a second. Let's get to questions. I need lip gloss. My lips are so dry. I was just looking for like literal chapstick. And it's still in my suitcase, but let's get to questions because you've got questions, I've got questions, we've got questions. Number one question that I have seen is why is no one prosecuting the Laundrie parents? And I will say this again, and I will say it continually. I don't think that there is anything that we have seen publicly that leads me to believe that the Laundries were aiding and abetting after the fact or obstructing justice. Aiding and abetting after the fact when you're not prosecuting the underlying murder is going to be difficult anyway without very clear and specific actions. Paying for a lawyer is not going to be a clear and specific aiding and abetting after the fact. There's no evidence that they were hiding anything that could be considered evidence, that they were, helping him do things to evade law enforcement. By the time that the warrant was issued in Wyoming for the use of the debit card, he was already gone from the house. So even if they did help him in a way that might be seen as evading law enforcement, there wasn't a warrant out yet. So without evidence of those things, it's really difficult to see where criminal charges would come. And we can't charge people with criminal behavior just because their behavior is sus, is outside of the bounds of polite society, is disturbing. Those are not valid grounds for criminal behavior. If there's evidence that they hid something, then maybe, but I don't know what they would have hidden. This was a manual strangulation case. It's not as if they're hiding a weapon. Paying a lawyer is not going to do it. The van, if they cleaned the van wasn't the scene of the crime. There was nothing to indicate the van was a crime scene or something like that. So there's a lot of what ifs there, but there's nothing that seems to be them actively obstructing justice. They didn't lie to law enforcement that we know of, or actively aiding and abetting him afterwards. Hiring a lawyer is not going to count. So if there's more that we don't know, then I might change my mind. But a lot of you have asked about obstruction of justice. What did they obstruct? They didn't seem to lie to law enforcement. Again, if law enforcement ask them questions, they're not obligated to answer. They're obligated not to lie if they do answer. And there's no information, factual information, that they lied to law enforcement. They're not required to talk to law enforcement. You're not required to talk to law enforcement. So you don't have to talk to law enforcement. So them not talking to law enforcement is not obstructing. Obstructing is actively obstructing, actively doing something to impede an investigation. Lying to law enforcement can be obstruction, but refusing to speak is not. So let's see. What else? So we're going to get through all of it. The cause of death mentioned no. Sarah, the cause of death from, and I did at least one episode breaking down what the cause and manner of death were. It was manual. So this was not done with a weapon, and no indication that anything was done with the weapon. Casey Cat said, held my Irish twin brother's hand as he left this earth Tuesday night after a long battle. Blessing for him, but feeling a bit lost. We are 10.5 months apart. Casey Cat, I'm incredibly sorry for your loss. And hopefully there is comfort in the fact that that seems like a better place for your brother, and that you were able to be there throughout life and when it mattered. So that is a difficult thing. And today is a difficult case to talk about all of the things. Again, from the beginning and back here, thank you, B2 and Bridget, for all of the incredible gifted memberships. It is tremendously generous. Thank you so much. Good to see everybody. All right. I see a lot of celebration texts. We'll get to those in a minute. I want to go to some of the Q&As. A lot of you want to see the Laundries in jail. Like, I get it. I get that you want to see the Laundries in jail. I don't see anything you can prosecute, and you can't prosecute people for being assholes. Some asshole-ish behavior is also criminal, but I don't see anything here yet that's prosecutable. And I lean towards prosecution most of the time, unless they're fucking around, and then I get real pissed. But if there was something that I could be like, yeah, you could probably prosecute this, why aren't they? I would tell you. The Real Deal asks, can the Laundrie's behavior be tortious even if it's not illegal? That's what we're going to find out. That's why we've got a civil lawsuit going. But we will see if the IIED is the way it's going to be, the way it's going to go forward. You don't have, there are not snitch laws. So you cannot force people to tell on themselves, Fifth Amendment, and you can't force people to tell on others unless they have a legal duty to do so, right? The Petito or the Laundrie parents are not obligated to report what their son said to law enforcement. They don't have to. So, they don't have to. Let's see. Which is why we end up in the morality, legality circumstance. EDB, you travel so much. How are you not a motion sick mess? Nishay, sometimes I am. Sometimes I am a motion sick mess. Sometimes I am not. So it really just depends on the trip. And it depends how much it takes it out of me, which is why there are days that it takes me longer to recover from travel than not. And it depends where I travel to. I had a lot of turbulence this trip, but was able to kind of work through it. Being able to lay down a little bit more and recline a little bit more helped this last trip, but it really just depends. But yes, I get tremendously motion sick. Flying into Atlanta and flying into Nashville both have a lot of the steep banking turns, and those are the ones that mess me up the most. So that is never helpful. I'm going to get to some more questions. Let's see. Emily, how do I get that music to play on loop while I work when you're not streaming? I need it. Which the music bed is my soundboard music bed, but Music to My Soul, I would just loop like Lo-Fi Girl or something because it'll be good. Josephine, this is a note, it seems, to all of the law nerds. YouTube is messing up the notifications. YouTube algorithms are constantly in a shift. Miss Opinionated, good to see you. Question, does Depp Heard set any precedents here? No precedent set, but the fact scenario came up at one of the earliest hearings when they were talking about whether or not they needed to bring in Bertilino or not. The conversation about the Depp Heard case did come up in court during a hearing for sure. Do you read this as the parents or Bertilino were searching for an attorney in the area where she was found? I read this as Brian Laundrie calling his parents after he did this saying, I need a lawyer immediately. I need a lawyer immediately. And knowing where she was, or knowing at least a little bit where she was. Diana B summed it up. I get it, but I also hate it. This is the difficult thing with law. Sometimes the legally correct thing is distasteful. And I absolutely get it. I don't like it either. I can't imagine I can't imagine this circumstance in my own life. And I have been adjacent to people dealing with their children being missing, and finding their remains in a close enough way where I have a very visceral response to this case. It's part of why I did not cover this case a lot. I have a very, very visceral response to this case. It hurts my heart. However, I also have a pretty visceral response to the legal, where you cannot force people to act against their own self-interest in this way. You cannot force people who aren't legally mandated to disclose things to disclose them. You can't. I don't think that would be a right result, though I don't like the result here. It's very, very difficult to navigate because the behavior here is just distasteful. But I know there will be some, and if you get a jury, there will be some but how can you force parents of an adult children to say anything when their child comes to them for help? If they actively obstructed, arrest them, right? If they helped him evade law enforcement, arrest them, prosecute them. That is a crime. But if they walked that line between he's not a fugitive yet because there's no warrant out for his arrest, and he's not doing anything wrong. He could have left the country if he wanted to. It wouldn't have been wrong. There was no warrant out for him, right? He legally could have done that. If they had helped him do that before a warrant's there, then what are you going to do? You can't arrest them for that. So Krista said, what about helping him escape? What was he escaping? There was no warrant for him. So what was he escaping? Tater Farm, do you have to report crimes? Not necessarily, and it really depends. If you're a mandated reporter, that's different. But if you see somebody get into a car accident, are you obligated to stop and call the police about it? No. In most circumstances, you're not. And people don't trust. There are people who are like, I don't want to be involved in any of this. So, no, you don't. If you see somebody drunk driving, do you have to call it in? I do. But do you have to? No. So no, you're generally not obligated to snitch unless, again, you are in a position where you are legally required. Mandated reporters are different. There are people who are reported to do different things. If you're off-duty law enforcement and you observe a crime happening, are your obligations different than if you are a civilian? Yes. So it really is specific to you. So Krista said, I understand the warrant part now. The warrants came in late. But, and I talked about this earlier in the show, the warrants, I think they were rushing to get a warrant on Brian Laundrie after they found Gabby Petito and had not put enough information together to get a warrant on the murder. And that's why they got a warrant on the use of her debit card. That was the first warrant they got, but it took them quite a long time to find where she was. Let's see. Mikhail said, maybe I missed something. Do we know for certain they knew? There's plenty of circumstantial evidence that they knew he needed help, but he might have refused to admit that he killed her. You are welcome to interpret the statement that he called them frantically and said, Gabby's gone and needed a criminal defense attorney, how you want. I think a jury is going to look at, he called them frantic the day or day after she was killed, saying that he needed a lawyer, and they got him a criminal attorney after saying she was gone, to mean that he told them that he had killed her and he needed help. I think that's how a jury will interpret that, but they said that in their depositions, and I covered that at the beginning. Question from Sam, can they request discovery for the contract that he is representing Brian and not just his parents? They didn't challenge it at all. Could they ask for that? Yes, they could. Did they challenge that? No, they didn't. So, Harlot said it was Gabby's van. It seems like it should be illegal to come home in your girlfriend's van without her and refuse to tell where she is. If she's dead, she can't report it stolen. And when people are engaged or live together, they often share property. So it wouldn't be considered stolen at that point because they often share property. Though they did get a warrant. They did get a warrant for the van because she was missing and were able to search the van. So that happened sooner than a warrant for him. Let's see. Rhonda Berry said, was this a brand new journal? Were there any other entries or was it all a self-serving statement in a new notebook labeled journal? Don't know. I don't have any more circumstance with that. Leonard Soph, good to see you. Sorry if this has been asked, but is there a reason why the Laundries can't be charged with aiding and abetting Brian if they knew that Gabby was gone? There don't seem to be any actions that were actually aiding and abetting. So what were they doing to aid and abet after the fact? And chat, I am so happy to have a conversation about this. I know some of you disagree with me. I'm happy to have the conversation. But going on vacation with him is not aiding and abetting him committing a murder. It's not aiding and abetting him obstructing justice. It's not aiding and abetting him evading a warrant or evading capture. I don't know what they're aiding and abetting. When their son comes home, she hasn't been found and there's no warrant out for him. So let's see. Let's see. Isn't failure to report a death concealing a body a crime? But the Laundries didn't do that. Cake and bake cakes. Brian Laundrie did that. Brian Laundrie, well, I don't know how much the body was concealed, but Brian Laundrie didn't report it. But he told them they don't have to tell anybody. And I don't know if he concealed it or not. And I don't know exactly what the laws are in Wyoming versus the laws in Florida. But I don't think in Florida, if somebody tells you they committed a crime, that you're obligated to tell anybody about it. Let's see. D-Trug said the right thing to do when called to say she's gone is to still arrange an attorney, but to assist handing himself in. Supporting your child still means making them accountable. I don't disagree with you morally. D-Trug is like, okay, well, here's an attorney, but also you need to go to the police. And we don't know that they didn't do that. So, yeah, we don't know that they didn't do that. So let's see. A lot more questions. Mama Wolf, what do you think would be an acceptable statement? What is it exactly Gabby's family is looking for in a settlement? Oh, settlement. Sorry. I don't know what they're looking for in a settlement. I think they're probably looking for an apology. I think they're looking for information, but I'm not sure what they're looking for in a settlement because nothing makes any of this better, right? If they win this civil lawsuit, it doesn't make anything better. How does it make anything? It doesn't make anything better. So I don't know what they are looking for. And I don't structure civil settlements. I don't know how much money the Laundries have or don't have. Money doesn't make any of this go away. Would they want attorney's fees covered? Yes. Do they probably want more information? Yes. Do they want their daughters, any possessions that the Laundries might have back? I can't imagine that they don't have that already, but if they do, maybe that. So I just don't know. But do I think they probably want an apology? Yeah. I think they absolutely do. I think they absolutely want an apology. So I don't know if they'll ever get it. Stephanie King said, I heard of the $25K retainer being returned to Brian Laundrie's estate. Does that negate the attorney-client privilege? No, it doesn't. An attorney retainer not only starts the process, but that amount that the attorneys keep is money that they use towards your representation. So it's like it's a little bank account for the lawyers to use as they need money to get paid. So they're getting paid upfront for work to be done. But if they get paid upfront for work to be done and then there's no work to be done, it has to be returned. But it doesn't undermine the fact that they were hired as clients, even though the money was returned. And I wonder if when this money was returned to Brian Laundrie's estate, because it seemed like this was the money from his parents paid, when it was returned to his estate, I think that's the money that the Petito estate settled for. But I'm not 100% sure on that, but it's the same amount of money. So we'll see. Can whoever is in charge of the estate waive the privilege? Sheila, his parents are in charge of the estate. I imagine that they won't do that. But could the estate waive the privilege? I would have to look at case law to answer that question. I don't know if an estate can waive it because the estate doesn't hold the privilege. The individual holds the privilege. So my initial knee-jerk, non-researched opinion speculation would be that that is a personal privilege held by the individual and the individual is deceased. The estate doesn't hold that privilege. So, the fight has to be that he wasn't Brian's lawyers. I agree, Jeanette. I don't know why they're not arguing that Brian wasn't represented by Bertilino. I don't know why they didn't argue that. Maybe they've already seen the contract and that's uncontroverted. Could there be other entries in the journal that discuss things that Brian and the attorney talked about? There could be, but they would have needed to have shared those. So we're not there. Question, can a lawyer talk about his client after the client's death if the lawyer wants to talk? No. I mean, this client I represented was a great person, maybe, but not regarding privileged communications. I don't understand how it's not accessory after. Hopefully I've explained that bedazzled and it makes sense. If you guys still have questions, let me know. You know what might help that we haven't done recently? Let's just walk through it real quick. Give me one sec. Because I still see questions. You guys are still like, but girl, accessory after the fact. Give me 1 second. I looked this up a million years ago, but we'll just pull it up real quick. Again, give me 1 second. We're going to look at Florida. Let's just see. All right. We are going to the Florida statute, and we are going to walk through it together. Law school is in class. Class is in session. Accessory after the fact. Any person not standing in the relation of husband or wife, parent or grandparent, child or grandchild, brother or sister, or by consanguinity or affinity to the offender, who maintains or assists the principal or an accessory before the fact, or gives the offender any other aid, knowing that the offender had committed a crime and such crime was a third-degree felony or had been an accessory thereto before the fact, with the intent that the offender avoids or escapes detection, arrest, trial, or punishment, is an accessory after the fact. I would need to go back and look at what this said before, but assuming it hasn't been changed, any person not standing in relation, parent. So parent are not going to be charged. And I don't know if they helped him avoid or escape. Did they help him avoid or escape detection? Did they help him avoid arrest? I don't know if they did that. I mean, if they weren't his parent and they gave him a car to go wander off into the sunset, maybe. But again, parent. Any person who maintains or assists the principal or accessory before the fact, that's before the fact, or gives the offender of any kind, knowing the offender has committed an offense of child abuse, that's different. Let's see. Any person who maintains or assists the principal or an accessory before the fact, or gives the offender any aid, knowing that the offender has committed the crime and such crime was capital life, first degree or second degree felony, or had been an accessory thereto before the fact, with the intent that the offender avoids escape, detection, arrest, trial, or punishment, is an accessory after the fact. So, because the crime would have been murder, and murder in Florida would be a life, first or second degree felony, potentially capital as well. Did they help him avoid or escape detection or arrest? Well, there wasn't a warrant out for his arrest yet, so did they help him avoid or escape detection? I don't know if there's any evidence of that. So if you guys have evidence of that, let me know. But when we get to first degree Did they help him avoid or escape detection? He was not a person of interest, and there was no warrant out for him. He was gone by the time the warrant happened, and before the warrant, they hadn't named him as a person of interest. So I don't know how they could charge him charge the Laundries with this. So, sorry, y'all. I don't know how Florida would charge them with accessory after the fact. And it seems that what they did was get him a lawyer and go on vacation and give him a car before the warrant was issued, but he left their house before the warrant was issued. So I don't know. Accessory after the fact is not as charged as some other things because it is difficult to prove. So you guys let me know what facts you think go to that. But paying for a lawyer is not going to be sufficient because that is a right. Not saying anything isn't going to be sufficient. I know people want the Laundries to go to jail. I just don't think there's anything to send them to jail on. They're just mad. I get that you're mad. Cooper Ridge, do we know they went on vacation? It seems to be uncontroverted, and they talked about it in their depositions. So we know that they went camping together and then came back. So, and I get that it's infuriating, but unless there's facts we don't know, which there may well be, but if I trust that if there's facts that we don't know, that it would have been prosecuted. Sam Nelson said, I wasn't being ugly with the Queen of Hearts comment. No winners here, just pain. I'm not sure what the comment was. I've got tears, headache, and not involved. It's a hard case. My bedazzled nails, I'm so sorry. My 19-year-old sister died in a single car accident on 10.5. She was in Mackenzie, graduated from Paris, 10, struggling. I'm not sure if you heard via the news. I have not seen the news. I'm very sorry to hear about the loss of your sister. Car accidents are absolutely the worst. It is just the worst. And I'm sorry for your loss, bedazzled. That's tough. And I'm sending you a hug from here. What if your state makes mandated reporters like Texas? Erica, I would need more facts on the mandated reporters. I don't know if parents are mandated reporters when their adult children does something. Another congrats for Rob. Lots of love for Rob and his engagement. I know we talked about that one. Ann Bell says, I need a new moisturizer. What one do you use? Thanks for you. I'm doing more self-care. Thanks to you, I'm doing more self-care. I use a combination of moisturizers, but I have been using our OneSkin, which is a sponsor on the podcast. They were on last week's podcast. It is a nice, easy 2-step. They have an eye cream and a face cream, and that's it. It makes it very easy. So particularly when I travel, having a 2-step system is very easy for me, but it really depends on if you want a 15-step Korean glass skincare routine, or if you're like, I need moisturizer skincare routine. It's really, really, really going to depend. But I do like the OneSkin. So the perfect live to be wearing my I have questions hoodie. I have a lot of questions here. These are more answers than we've had, though, and I'm absolutely surprised at how candid the Laundries were. So I'm surprised they raised or waived their attorney-client privilege. So that's what I'm surprised of. Let's see. Question: if he were a person of interest, would he be required to report to law enforcement? Not necessarily, because there's no warrant. They can't restrict his movements. But if he's a person of interest, they can track his movements a little bit better. but I would need to look at Florida specifically. I don't know if the parents were required to tell law enforcement, even if he was a person of interest, but the parents didn't hide the fact that he was at the house. They didn't tell law enforcement when he left the house. I just wonder if they failed to tell law enforcement or if they told law enforcement something different. My question in this entire case with regard to what the parents did or didn't do was when they said, oh, he said he's going to this park versus that park. I wonder if that was misleading enough. But even then, they were still out there when he was found. And I don't know if that's something that we're going to see prosecuted. If we were, we would have seen it already, you know? So I don't think we're going to see any, unless something else comes up. I don't think we're going to see any more. Jay Meadows says, is there evidence in the autopsy to support Brian's story? From memory, the autopsy involved a head injury. But I don't believe there were any lacerations that would indicate it was like a rock, but could have been. But there was head injury and then the strangulation, and he did say he killed her. So that supports. I don't know, because it was a number of days, she slipped and she was cold. I don't know. They wouldn't be able to determine that, whether or not she had lacerations on like a knee or a leg or anything that would have showed that she slipped in water. I don't remember specifically, but the manner of death is in the same manner that he talked about. So Evie said, I'm also a typo queen, but Otto is my best friend when I'm texting, let alone if I wrote something like this. And the problem with the typos in all of the law things that we went through today is they were not misspellings. They were just wrong use. D. Trugo said, I truly believe the whole point of this litigation is to get to discovery. I thought so too. From the beginning of it. Today's chat reminds me of how my mom's horror when my reaction to her friend's external fixation for a bad fracture was, yeah, that sounds appropriate. She kept redescribing it and I stayed unhorrified. It's like, no, yeah, that's what happens. Mm-hmm. Right. Yes, my brother was working and had a DB float up, and we were talking about it at lunch with my parents, and my parents are just like, and I'm like, no, wait, there's studies on how fast bodies travel in water with the tide and blah, blah, blah. I was fascinated by the conversation. My parents were like, and I'm like, look, my brother's a lifeguard. It's not often that our worlds collide. It's rare. We need to talk. So I'm in the I need moisture camp. I need it simple. Try OneSkin. They are a sponsor on the podcast. I think you will enjoy it. And it is easy, and it is good moisturizer. In the argument that Bertilino could only assert privilege to protect his client, would Bertilino be able to assert on behalf of his client's estate, such as in the now settled lawsuit against his estate? Bertilino doesn't represent the estate, and it's a personal privilege. So I'm not sure in what context that would come up, because this is a personal privilege. But personally protecting, they're not protecting the estate. He's personally protecting his client's reputation, et cetera, et cetera. And that's not, Noelle, that's not the crux of the conversation. It's not like, what are you protecting him for? He's deceased. It's, was it waived or not is the crux of it. Was there an attorney-client relationship, and was it waived? Those are really the two conversations. Hopefully that helps. Let's see. Casey Cat said, I texted my kids and said their uncle was gone. It was not, however, followed by, I need a criminal defense attorney. They knew what he meant. I think they knew what he meant too. And I don't think it's uncommon that people say someone is gone to say that they have passed. It's definitely not uncommon. Morgan said, do they have a trial date? It's in May. Oh, I was going to pull up the docket because there had been some rumbling about whether or not the judge had changed. So give me 3 seconds to pull up the docket on this. So it's going to take me just a moment. My brain always pauses each time I have to navigate a different court website. There are so many of them. This is not the one I want. That's what I want. So there are so many different court websites to navigate. And I wish that the state system had a pacer. I know it's impossible. It's like, Emily, what do you wish you could wave a magic wand and make happen? I wish all court systems operated this. I wish they all operated the same. That would be so nice. Just all of you do it similarly like the federal system, just in one place. It would be so good. It would be so good. Let's see. This is still assigned to Danielle Brewer. I don't know if it's staying in her courtroom. It might have been that this changed because I thought it went to her and then it went back to him, but maybe it's still before her. I would need to double check. But yes, the judge is currently listed as Danielle Brewer, and she was in the last 2 hearings, but then the judge from the Take Care of Maya case was also in there, but it looks like it is assigned to her. So I don't know if he was just handling motions, but she is still listed as the assigned judge. Let's see this last order. Whose order it was. Yeah, the last order was signed by Judge Brewer too. So I wonder if it was permanently transferred and why I didn't think that it was. Either way, we'll see on the 20th who's sitting in the chair. So there we go. I went and looked. Let's see. Brian said she is gone. How does that equal murder? Steve, I think we just talked about that a little bit. I don't think it's just that Brian said she was gone. I think it was the full context of also asking for a criminal attorney, also having a $25,000 retainer put down on a criminal attorney, also having a criminal attorney retained in Wyoming, also contacting the public defender's office in that county in Wyoming. I think there's more context than just Gabby's gone. And then he came home in her van without her. So I think all of those contexts, there is a reasonable argument to be made by attorneys that the Laundries understood what Gabby's gone meant when their son was frantic and said, Gabby's gone, I need a lawyer. Different than just Gabby's gone, as we just discussed. So I think. So let's see. Don't the Petitos have to prove that the Laundries knew? I don't know if they can prove their case without proving that the Laundries knew. And I think that these depositions go a long way to do that. Matt Bond said, yay for my spiffy mumbo jumbo legal talkie brother from another mother. I know. Go send Rob congratulations. Hello from Iowa, making sugar cookies and drinking coffee. I love sugar cookies. Of all of the desserts, cookies and cakes are definitely my favorite. Rob is still on the menu to view. We just can't order him anymore. Elizabeth. Go get one of the pour one out for the thirst shirts that Ian has. That's hilarious. But can we send him something with wood stack on it as a gift? I'm sure. Send him all the stacks for his wait, no, not those kind of stacks for a wedding gift. Cindy said, love being a laundered. Can't wait to discuss this case. I'm interested to hear what they knew. I hope you're still interested and not horrified. Angel Nikki said, I've been following this case from the beginning. It's been really interesting, isn't it? We need to, let's see. Vicky said that, and why would she leave her van with Brian? It was her van. No, it was absolutely her van. And if she left, you would think she would leave him without the van and take the van, right? Right? I think so. All right, Lawnards. It is Thursday. If you have not watched this week's podcast episode, please go show the Emily Show some love on your audio or video platforms. I have a bunch of stuff I have to catch up on tomorrow, so I'm not going to be able to stream tomorrow. I was hoping to. It's not going to happen. I always think I have more time in the day than I do, but we've also been streaming for almost 4 hours, so I'm not surprised. We have food court to catch up on. We have texting judge to catch up on. We have Brittany stuff to catch up on. I feel so behind, so I'm trying to prioritize what we're talking about to mix in things that you guys are highly interested in and things that are timely. I think the first thing we're going to have to talk about next week, It's Courthouse Becky. I think the Courthouse Becky stuff has gotten crazy. I think that's the first thing we need to talk about. We have a lot of Courthouse Becky stuff to talk about, but we also need to talk about texting judge. So we've got some food court that will be coming up. We've got Courthouse Becky stuff that'll be coming up, but I expect that the rest of the more criminal stuff is going to simmer. It is getting to that time of year where nothing happens till the middle of January. So I'm hoping to be able to catch up on some of this civil stuff as the criminal stuff takes a breather. But I think our next live stream is going to have to be Courthouse Becky and that ethics complaint, because boy, oh boy, it's wild. Let me know if you guys enjoyed this week's episode where I break down the Young Thug YSL case, if that was helpful, if breaking down the RICO statute was informative, because I might keep up with that case a little bit through the podcast or through quick bits, depending on your interest in it. This case I will be keeping up on. Let's see. Do I have a calendar? Wait, I have a phone. Let's see. And I also know it's the time of year where y'all are busy, so that it's hard to judge by views whether you're interested or not, because it is a busy time of year. So the next hearing in the Petito case is on a Wednesday. So we'll have to move things around, but I will be covering that hearing on a Wednesday. So with all of that, we have only a few live streams left for the year because I will be taking some time off in the holidays. All of you need to. I will probably be taking some social media off my phone during the holidays and just take some downtime. We'll also have some stuff coming up for our members specifically. Hoodworm! It's our anniversary. Yay us. All right, y'all. Don't forget to do all of the YouTube-y things. I appreciate it. More question, Emily. I have a feeling what he wrote in the journal was to save face for his family, probably. They may have known what he was going to do. I think they might have. I mean, I don't. It feels like they knew that either way, that was something they were going to lose their son. And I think that's why they all went camping. Kind of like, let's spend one last day together, because they knew that they were either going to lose him to prison or he was going to be gone. So I think that that's what that camping trip was. I don't think it was to help him evade the arrest. I think it's because they knew that one way or another, their family was never going to be the same again. That's kind of my just gut feeling on it. We have lots of food court to do. Can we talk about how perfect the Courthouse Becky moniker is? Really is. Ms. Fitness said, Brian just forgot to say I told my attorney in his note. I mean, I told my attorney all of this too. Anna said, after this, could the state file charges so they cover the cost of the searches to reinstate the funds to the taxpayers? I don't know what mechanism they would use to charge. His estate doesn't have any money. So I don't know, unless the parents had them searching in the wrong place and maybe go after the parents civilly for reimbursement. But I don't know what mechanism they have in Florida to do that. So with all of it, it is time for me to go. It has been much, and it has been late. So with all of it, it is time to go. With all of you guys, thank you for being here. Thank you for being law nerds. I think I got to everybody's questions and super chats. Thank you, Ario Scorpion. It's good to see you. I am going to go get some rest and unpack. My office is a mess. Happy holidays. To all of you that have already sent me Christmas cards, thank you for the holiday cards. It's always fun to see y'all and your family, so thank you for that. And law nerds, I'll talk to you in the next one. Take care. That's the longest goodbye ever. YouTube, Emily, make your outros quicker so you don't have fall off in viewership. We're law nerds. We do what we want. Take care. I will see you guys in the next one. Bye.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media. And don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.